The Honorable Supreme Court, in a catena of decisions on the aforesaid subject, has laid down that the onus is heavy on the person who alleges any unconstitutionality of any act, and that burden has not been discharged in the instant case. We are of the opinion that citing certain hardships by a private party cannot be a ground for interfering with an act which has been enacted with the broad objective to bring a regulatory mechanism over private institutions, education, and streamlining the functioning of such institution, as the same is directly in sync with securing a better future for the children who are the assets of the country. In view of the aforesaid discussion, we are of the opinion that no case for interference is made out, and accordingly, writ petitions are dismissed. The interim order, if any, including the observation made in the order dated 22/2/16, stands vacated. That's it. And then coefficients. In view of the aforesaid facts and circumstances, we have the opinion that the impugned order dated so and so does not call for any interference. Accordingly, the petition being devoid of merits is dismissed. Being dismissed as equivalent. Last question equivalent. Yes.
Thank you, Your Lordship. I beg to
Yes, who are these new persons in the new advocates, new enrolled? What are they doing here? Okay, okay. Let us wish you all a very happy Children's Day. God bless you. Okay, we'll interact with you after a while. Be prepared. And one of you plays guitar, I think. Okay, we'll interact. Yes.
Please, Your Lordship. I beg to mention item number 1, Lordship. Kindly matter will be adjourned.
Adjournment, 20 matter. Sorry.
That my senior is out of station, Lordship.
Who is your senior?
A. Ali.
We are not adjourning 20 matter. Adam. Sorry. Yes.
I beg to mention for listing for motion, Lordship. Monday, Lordship. Okay.
Don't put it Monday. Kali khula niki. Kali khula. Okay, Monday will have.
May please, Lordship. So I beg to mention item number 30, my lord. Okay? Hearing matter, my lord. It will come next week, my lord. If possible, my lord.
30?
30. Yes, Lord.
Yes. 20 matter. Yes.
Hearing matter, my lord. It will come on next week, my lord.
Why? 20 matter we are not adjourning.
My lord.
We do not know anything. 20 matter we are not adjourning.
My lord, hearing matter, my lord, could not prepare and last night, my lord.
We have also not prepared, but we'll do the matter.
My lord, I was in hospital.
Let it preach. Let it preach. We are not adjourning matters of 20.
Not a hearing.
Don't make prayers for adjournment unless there is some grave urgency. Somebody is ill in the hospital. Otherwise, no. Not preparation. Brief not there. We are not going to
Brief
accept.
is available, my lord, but I am not.
Sorry. Next.
May I please, Lordship? So I beg to mention for listing on a writ petition criminal matter for admission matter. It was the last listed on 28 October, but not remain left over matter. Monday,
What is the subject matter?
custodial disappearance matter.
Custodial disappearance.
Disappearance.
What are you seeking in the writ petition?
Till date matter.
What is your prayer in the writ petition?
To find out whether alive or dead.
Habeas corpus.
petitioner. Yes, ma'am.
Okay, next Wednesday.
Original. Much
Because of sudden medical emergency, I could not take preparation. Item number 21. Can I pray for it?
Item number?
Item number 21, Lordship.
Which year? 18 matter. We have refused 20. How can you give 18?
The issue is, yes, I know that I should not make such a submission, but I could not
Not
take
now.
preparation.
Not now.
I may not be able to assist the court properly.
What is your difficulty?
Because of sudden medical emergency, even then I could not go through the brief also, Lordship.
You stay, wait for a while.
Lordship.
May I please, your Lordship. I beg to mention item number 5, Lordship.
5.
Yes, Lordship.
Yes.
Kindly adjourn for 2 days, Lordship. I'm not prepared 2 days, Lordship.
Item number 5.
5.
On a request, yes, 5, Mr. Sharma. Yes.
Next week, three.
Item number 5, on a request made on behalf of the petitioner, matter is adjourned to be listed
Yes.
on Wednesday next.
Yes, Lordship. Obliged, Lordship.
Date.
May I please, Lordship, I beg to mention item number 4 for adjournment.
4, yes, what is it?
Our arguing counsel is not available.
Okay, after 2 weeks, on a request made on behalf of the petitioner, list matter is adjourned to be listed for 2 weeks. Yes.
Obliged.
May please, your Lordship. I beg to mention item number 29, my lord. This
Hmm.
matter may be taken after 2 weeks.
Matter of which year?
2022, my lord.
Where are you seeking time of 22 matter?
My lord, Mr. M. Hussain is with this case, my lord. He is some problem, my lord.
On a
After
request,
2 weeks.
on a request made on behalf, oh, this is what, retribution criminal.
Yes, my lord. I have already
Why
informed,
revenue is a party here?
already informed. 29.
Item number 29, why revenue department is a party?
29.
Okay, on a request made on behalf of the petitioner. Matter is adjourned to be listed after 2 weeks. Yes,
Oh, Lordship.
Lordship, I beg to mention for listing of IA, Lordship.
IA for what?
I for correction of post title.
Okay,
Obliged.
Wednesday next.
May I please, your Lordship.
Pertaining to a DB matter, DB2 matter.
Yes, Lordship.
Lordship, I beg to
Cost
mention,
title in what case?
FT matter, Lordship.
Lordship, I beg to mention item number 7 and 17 for adjournment for today. I have already provided adjournment slip yesterday. My senior is out of station.
17, item number 17 is a matter of 2017.
Lordship, a short date may be given. My senior is out of
Who
station.
is your senior?
AR Sikdar.
17 matter, we do not adjourn like this. You
Okay,
have
for
to, you have
short
to
date-
be here, we'll have to check the records, we are not going to adjourn. 7, what is 7? 7, we can accommodate you. On a request made on behalf of the AR Sikdar, matter is adjourned to be listed after 2 weeks.
Lordship,
17, we are not passing any orders, you have
for
to be
short
there.
date, Lordship, for a short date 17.
We are not passing any orders now. You be there when the
It
matter
was
is called
actually
upon.
for COB by
You have to be there when the matter is called upon.
May it please, your Lordship, my lord, I beg to mention item number 10, your Lordship.
10,
Right. Item number 10, your Lordship.
yes.
May kindly be adjourned for a week, your Lordship.
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
Do oblige.
I beg to mention for listing, my lord. This matter has been listed earlier for 2 days, but 2 days has been left.
My
over.
what matter? Matter is pertaining to what?
My lord, FT matter, my lord.
When was it last listed?
My lord, earlier listed, my lord, 25/7/2025. Later on, my lord, 1/9/2024. But on both this case has been
Matter of which year?
left over, my lord.
Matter of which year?
2025. I'm filing-
25 matter. Not out of turn to listing, sorry.
My lord, I am apprehending arrest, my lord.
25 matter not out of turn listing. File an IA, we'll consider.
My lord, I have filed, I have.
File an IA.
Bail, my lord. In the.
File an
requisition,
IA.
my lord.
Have you filed an IA?
Not I am, my lord.
You have to
In
file
writ-
file IA.
In repetition, my lord, I have
You have to file an application.
honorable court. was
There are many
issued-
matters, Mr. Council. We cannot, out of turn listing by a mention memo, we do not give. Unless you
Listed
get it.
for but left over, my lord.
You file an IA. Not by a mention memo, sorry. Had it been an old matter, we had to consider. Yes, next.
So kindly today only, for today only matter will be passed over.
See, this matter is at the stage of motion
Yes,
for
Lord.
the last 5 years. What answer will you give to your client? 5 years matter is pending and the blame is on the court. 20 matter we cannot adjourn, madam. Where is your brief?
Actually, I'm not aware in this matter, Lordship.
You need to have the brief.
My chamber is closed. He is Kolkata, Lordship. My senior is in Kolkata.
Okay, on Tuesday we'll have this matter.
Sure.
Mr. Pine, Tuesday for disposal, okay? A prayer for adjournment has been made on behalf of three.
Ke
On behalf of
Tae? Tae.
item number one,
Oh, okay, A Ali.
on behalf of A. Ali, Learned Counsel for the petitioner. Full stop. We have however noted that this matter is at the motion stage since the year 2020. Para considering the above, while accommodation is granted, comma, this matter is directed to be listed for motion on Tuesday next.
Obliged.
Yes, come forward. DPS. Who is the smartest amongst you? No, who is the smartest amongst you? So we are putting the question to the list of the smartest. We are putting to the lady. You are not smart? You have to come forward. No, lady in the yellow. Because you showed somebody else. What is the full form of your school?
Delhi Public School, Guwahati.
Guwahati. Why a Delhi public school can be in Guwahati? It should be in Delhi.
Guwahati branch.
Guwahati branch.
Different branches.
Okay, when was it established? The DPS? When and where?
2003.
Hmm?
2003.
Not your school, DPS. When and where? You do not know of your school. How many DPS are there in India? How many DPS are there in Assam?
Now.
Hmm?
7.
Only 7. More than 10. There has to be one answer. Your teachers are watching you on television, on YouTube. They'll ask you, you do not know the numbers of DPS in Assam.
The first DPS was established in 1949.
19? Where?
In Delhi.
Delhi. DPS was in Delhi. Are you sure?
Yes, sir.
Not in Assam. Which one? How many DPS are there in Delhi?
Almost 5.
Almost 5. More than 5. There has to be one answer. Which is the subject which you like the most in school? Science. Okay, I'll put you a question and then you can all leave. but you have to answer and think because you need to keep focus. It's a very easy question. Okay, all of you can answer. But listen to the question carefully. Okay, it's a very easy question. You know what is a kangaroo? What does a kangaroo becomes after 5 years?
Five-year.
What does a kangaroo becomes after 5 years? Where are kangaroos found? Which countries? So what does it become after 5 years? You have lost focus. You have to focus on the question. It becomes 6 years. Okay? So you need to keep focus on the question. Only because we have said kangaroo, you have thought of something else. After 5 years, it becomes 6 years, isn't it? Okay. Enough. We have got many other works. But you need to stay focused. And mobile use should be limited. We are not saying that you should not use a mobile, but limited. Okay, all the best. Yes. Who's with you? This record have come, Mr. Rashid?
Yes.
No.
Records are there.
Okay.
Item number 2.
Okay, we can take this up for disposal.
Impugned order number 30/1/20, answer 6, page 39 to 55. I received a summons from the court, from the tribunal. I appeared. Sorry,
Let us go through the impugned opinion first. Okay,
page 39,
it's 30.
39.
39.
My lord.
Yes. Yes, please. Dates of the opinion,
30th January
2020.
2020. Mary. This is I file a statement and also DW1 myself and DW1 myself, DW2 Gaura and my brother DW3 and Latmundol DW4.
31/2020.
My lord.
This is which FT? 6. FT6 Borbeta.
Borbeta.
Your name is Samsul Haq.
Samsul Haq.
Okay, how many DWs?
DW4.
4.
Myself and Gaura, my brother and Latmundol.
And Atmandal. Okay, please, let us hurriedly go through the opinion.
Opinion, my lord.
It's a contested matter. You have 4 witnesses. Okay.
My lord.
Written statement. No, the references. Okay. 20 months. 25 only.
And exhibits, my lord, I have mentioned here, he mentioned in the case for John. Page 41, exhibits, my lord. Exhibit A, voter list 56, that is other mother.
Discussion to solve ভালো করে। Discussion to find out if the easy হবো। At least এদিকে না হাকে কিনে হাকে এখানে Come to, we start, read from paragraph 9, okay?
My lord, it is.
Page 43.
Now coming to the evidence made in your.
Yes.
Now coming to the evidence part. OP examined himself as a DW1 by way of finding affidavit on 16/6/2016 on perusal of the affidavit. Okay. It is found that in the affidavit, though OP had more or less reiterated the same narration of his pleadings, but there are some variations found between OP's pleadings and evidences. In this WSOP stated vaguely that his father had expired before the year of 1997, and in the voter list of state year, that is in the 1997, along with his mother, his own name had appeared. But in the affidavit again, OP, without mentioning the specific date, stated that after the year of 1985, his father was died. The statements regarding his father's death are found to be contradictory and have variations between that, and no documentary evidence had been submitted by OP to prove the death of his father. Without any documentary proof, if OP had made a contradictory as well as vague statements about his own parents' particulars, then it can only be held that such statements had no value or credibility. Paragraph next 10. Notwithstanding the same, what is discernible from the perusal of WS and affidavit is that we had claimed to be an Indian since his father's name had appeared in the voter list of 1966, 1970, and 1985. Pertaining to village Agmondia under Barpeta district, Assam, hence being the son of Dhatu Mia and Sampatan Mesa, he should be declared as an Indian by birth. But to substantiate the said claim, firstly, OP had to establish his linkage with Khatumia as his biological father through present reliable and admissible evidence, and thereafter he had no proof adequately the existence of his parents in India, Indian soil relative to the period on or before 25/3/1971. 11 million. After going through with the entire material available in the case record, it is found that OP had submitted a Gawra certificate dated 23/2/2015 issued by the same by on Alhaj Hazrat Ali. The Gawra under charge number 15, this document was exhibited as Exhibit 3, but this document is inadmissible due to the unauthorized use of state emblem on the top of the certificate. I mean, there was a certificate, the top money on state emblem. 12. Page 45. However, to prove the said document, OP had examined the concerned Gavura as DW2. In his oral testimony, DW2 stated that OP, being a resident of village Agmondia, he had issued the certificate to him. Since he knows OP from his childhood and on the basis of his personal knowledge, DW2 stated that OP is an Indian citizen, but he failed to disclose the name of OP's forefather, and the name of OP's parents. He also failed to disclose when and where OP was born and brought up. DW2 merely stated that OP is a resident of village Agmondia as a reply to the tribunal's queries. The Gavura had stated that he does not keep any population register book. He failed to submit any document or a record pertaining to village Agmondia and village Bhairarpam. DW2 failed to prove the period of inhabitancy of OP and OP's parental family in village Agmondia. Without any contemporaneous record pertaining to village Agmondia, the testimony of Gavura cannot be considered on the basis of his personal knowledge as observed by the Honorable Guwahati High Court in WBC number 77 as the result that it is to be borne in mind that the contents of the certificate would have to be proved from the record through the author of the certificate may prove the document through oral evidence, but oral evidence, the horse record cannot prove contents. Contents of the document based on a record cannot be proved from personal knowledge. Paragraph 13. Admittedly, OP could not able to his linkage with the projected father, namely Ghatu Mia. However, OP had examined on Talibur Rahman. Talibur is the brother. Aged about 59 years old, son of late Ghatu Mia, resident of village Agmondia SDW3, by way of filing affidavit on 14/9/2018. In the affidavit, W3 had stated that OP Shamsul Haq is his brother, but neither in his pleadings nor in his affidavit OP had mentioned about having a brother, namely Talibur Rahman. But on this claim, it is required to revert back to the office pleadings, neither in the WS nor in the affidavit OP had mentioned anything about his siblings. Neither OP disclosed how many children his parents had, nor about their birth and birthplace. Therefore, a sudden appearance of a brother, namely Talibur Rahman, had only a invite to be cautious and circumspect in accepting the veracity of the testimony of such interested witnesses, unless it is corroborated by other reliable and acceptable material. Material evidence on the perusal of DW3 testimony of it is found that some and except the statements of being the brother of the OP, no linkage between him and OP have been found or to be established through any cogent and reliable evidence. Paragraph 13. Notwithstanding that, while pursuing DW3's testimony, it is found though he had stated that OP was born in year 1980 at village Agmundia, but there no documentary evidence has been placed by the DW3 to prove his statement. Moreover, the statement of DW3 regarding the birth year of the OP, that is the year of 1980, contradicted the age disclosed by the OP. In the affidavit filed with the WS, dated 16/7/2015, OP disclosed that he was about 37 years old. As per his age, OP ought to have been born sometimes in the year of 1978 instead of 1980. 15. About his own self, DW3 had merely stated that he was born at village Agmundia as per the age disclosed in his affidavit. DW3 ought to have been born sometime in the year 1959. But while he was cross-examined on 22nd November 2018, DW3 admitted that he did not know his date of birth, but stated that in the year 1980 he was born at village Agmundia. Apparently, DW3 had contradicted his own year of birth. He had also failed to submit any proof of his birth in the year of 1961 at the village Agmundia. Since he had contradicted his own birth year, hence a doubt arises in mind about the evidentiary value of the testimony of DW3 in regard to his statement. Linkage of OP, DW3 had also failed to submit any documentary evidence where the linkage between OP and OP3 can be ascertained. Just for this one, paragraph 16. DW3, as proof of his own identity, submit an electoral photo identity card as Exhibit X. Apart from that, he stated that his name had appeared along with his parents in the voter list of 1985. That is Exhibit C. He also stated that his name had appeared in the voters list of 1989, Exhibit E, 1997, Exhibit B, and 2010, Exhibit Y. Pertaining to village Agmundia, on perusal of these voters list, it is found that the entries made in these documents had also found to be contradictory, which are discussed in the following paragraph. In Exhibit C, that is the additional voter list of the year 1985, under house number 196, there are four voters' name had appeared, that is Ghatu Mia, son of late Janur Ali, Sampatan Nessa, wife of Ghatu Mia, Ghaznavi Miah and Talibur Rahman, both are both son of Ghatu Miah. The age of Talibur Rahman was entered as 37 years, and in the approximate of 1st of January 1985. As for the age of these documents, Talibur Rahman ought to have born sometime in the year 1948. Whereas, as per the electoral voter photo identity card, Talibur Rahman ought to have been born sometime in the year 1959. That is, DW3 had not given any plausible explanation about the discrepancies found in regard to the entries of his age. Since the entries of these documents were not proved in accordance with the law, hence on that account it cannot be held that the entries made in Exhibit C refer to the Exhibit D, Exhibit DW3 and his family. Paragraph 18. In the cross-examination, DW3 had disclosed that though he cannot remember in which year he had contested vote, for the first time, but stated that he was about 25 years old when he casted a vote first time. Now, if DW3 was born in the year 1955, then he had attained the age of 25 years in the year 1980. But there are no documents had been submitted by the DW3 to prove his self-statement. However, on the perusal of the voter list of 1985, particularly Exhibit C, it is noticed that the voter Talibur Rahman was about 37 years old. He had also disclosed in very casualty
Mr.
that
Rashid, we have more or less gone through the opinion. You have to make out a case. Let us see what are your documents, which according to you have not been properly appreciated.
but not only like evidence and I have submitted documents, will kindly see that is page 41.
41,
41. Pro, yes.
not 41.
Yes, sir. 41 exhibits. List given here.
Yes, no, let us see the exhibit.
My lord.
List we have seen. Page,
Understand? First will have page 56. Annexure 7.
56.
56, Annexure 7. Here we learn the name of my father, Khatulia, and my mother, Samparan Nessa. That was 1966.
This is a certified copy.
My lord. Yes, certificate committees.
57 is the vernacular.
57 is Vanikata.
And the voter list of
1966.
name, Gatumia is your father.
Father. And Sampatan Nessa is my mother. Next, my lord, page 58. Total list of 1970.
What is your age?
Now, my lord, I am 41 years in 2020. Well, 45.
You're
Yeah,
around
today.
45 now.
My lord. At the time of filing, it was 41 years, so it is 4 years past, 5 years, 45 years.
So your date of birth would be around what? 1980.
80 around, yes, 18, yes, rightly, my lord.
When did your father pass away?
That is, my lord, I have mentioned in 85. After 1985, my father expired, my lord. And
After?
that is before 1997. After,
Within 12 years?
yeah,
We do not
yeah.
know.
Exactly, there is not mentioned, my lord, what is in record, my lord.
No, that we have understood. You cannot answer that. You are handicapped. But
That is record, what is on record, my lord?
that is the pleadings, 85 to 97.
Seven. In between, my lord. When my father name appeared in, my lord, 1985, yes, 85 my father name is there, and 97 my father is not there. That means, my lord, in voter list. So, my lord, in between, he expired. And page 56.
No, won't that raise a serious doubt? You are trying to extract an information of the death of your own father from the voters list. In 1985, his name was there, so he was alive.
Actually, what happened?
In
my lord?
97, his name is not there, so he must have died sometime in
No,
between.
actually, what happened? My lord, I am,
So it can, is it a
I
believable,
have-
is it an acceptable theory?
Exactly.
Postulate?
what my submission lordship is, what exactly had happened, my lord? I am an illiterate person. I have no knowledge about the death of my father, mother, etc. my lord.
You
Even,
don't have,
even my date of birth, I don't know.
illiterate person will not know the death of the father or mother. You may not know the date of your own date of birth, your own date of birth.
My lord.
That will be told by somebody also. That also, that may not be corrected, but will certainly know. Even the most of the illiterate persons, they know that they were born in the year so and so, in the month of so and so. But when your father passes away, your mother passes away, and that is why we have asked you, you seem to have born sometime in the year 1980.
80.
So if the
Approximately.
father has passed away between 1985 to 1997, and you do not know when, you know
Exact date.
he passed away in a span of 12 years.
No, cannot. And within this period, 1985 to 97, 85 million, of course, I was 5 years old. Or 6 years.
85, you are 5 years old. 97,
97,
you are 17 years
about
old.
18,
17, 18 years old.
about getting maturity. But this period, actually, what am I telling you, what thing, fairly, the relevant advocate who is dealing the matter, he also did not ask the question, this relevant question. When your father died? Father, I don't know. My brother knows. Elder brother is there. Mother is there, he knows. Yes, 5 years ago died. That question never asked, and so that question remains unanswered. Close. And when it is coming to the upper to the that is the relevant question. When your father, what time he died, what was your age at the relevant point of time? This question are always in subcase. But when it's coming to your lordship or important question, then it.
See, this proceeding of yours is not the first proceeding that you do not know what are the questions to be put, what is the written statement.
Yes.
You had contested the case. You had 4 numbers of DWs, including the Gaumbur and Latmandal. You do not say that you are not aware of the procedure. We have seen matters where there is no DW, a single DW. They may not know. We have seen matters where there is one DW, the proceeding. But here, apart from you and your projected brother, you have the Gaumbura as well as the Latmandal.
And in Latmandal Miller also my name appeared as
Where?
in land Miller, my
Land.
name appeared in place of my father. That name mutation in land Miller.
Let us see, that is why we'd like to see the documents, the
Yes.
exhibits.
Land
First
Miller
is
case,
1966 you have shown to us.
yes. Nineteen
voters list.
1970, Your Lordship, may I kindly see
Age?
page 58. My father's name and also my mother name. And particular minute, page 59. And it is same to same minute, almost with 70 and 66, almost same minute. Only
Yes.
minute the age is increased.
Yes, system.
And 60, page 60 minute, 1985.
Page
Page minute 60.
60.
Right. And village is same. There is no shifting minute, village Agmondia.
Got to 75.
And mother,
But see the age.
my lord,
See the age of Gatu and see the age of Sampatan.
my lord, 65, and father was 75, mother was 65.
No, no. In the earlier 1970, father was 49, mother was 30.
Hmm.
Now, after
15 years,
15 years, the age is double.
for 50.
Father becomes 75. Mother becomes 65.
It should have been 65, but they are making 75. 30. And yes, Your Lordship is right. 30, it should be like 45, mother, but then 65. Actually, these are the power of the innovators. They mention their names as they like.
T. See, if you go by this voter list, you have said your date of birth is 1980. And 1980, your father was, what was the age of your father at the time of your birth?
80 million.
Mr. Payang? At the time of his birth, the age of the father would be how much?
70 years.
70 years.
Mother will be 60 years.
Remarkable.
And two brothers' names also there. They will be more than 41 years and 40 years elder than the mother petition.
And as per 60,
And
70
there is
voter
no other
list, sir,
siblings in between.
as per 60 voter list, in 80 million, I will be about 59.
60-year-old mother can a mother of 60 year bear a child? Father, okay, exception.
Father, at the earlier voter list, father would be about 59 years. As per earlier.
Let us give the benefit of doubt to the
Now,
father.
if we go back, it is
Father
right.
gets
and it
benefit
can
of
come
doubt.
again.
Mother at 60 years, can you, a woman of 60 years, procure a child?
See, when the wrong calculation, wrong mention, it's not possible probably, I have no that science knowledge, I have no, but. as per-
You're trying to go
Yes.
to include yourself into your family, which is not known to you. That is what is happening.
Not that.
There has to be some consistency, some reasonableness, some acceptability.
These are wrong information or wrong calculation. Actually, those are nothing. Wrong calculation, wrong information.
No, you see from the, it cannot be a wrong calculation from the beginning. You have given the voter list of 1966.
That is
Even if you go by 66, your father was,
70 million, I think.
your mother was around 30 years, 66.
My-
You were born in the year 1980, isn't it?
My lord.
Okay, then what else?
And luckily, my lord,
Page 60 we have seen then. There is 60 there are two brothers.
my lord, two brothers.
Ghaznavi.
Ghaznavi Mia and Talibur
Talibur.
Rahman. And my lord, page 62.
Ghaznavi is what, 41 years. And Talibur?
Talibur was my lord, he was the Peter DW2 my lord. Talibur was 37 years.
37. And you are 5 years.
4 years, yes. And kindly see my lord, page 62, total list of
Your
1997.
brother is 37 years, you are 5 years. In between, who are there? Is there anyone?
No, these three, only three my lord. And mainly
No, it is possible that you may have several siblings. There may be a age difference between the eldest and the youngest. But after Talibor, who was 37 in the year 1985,
And
next appears to be you, but you are 5 years.
sometimes happen, my lord, your lordship have the idea, my lord, in our caste, my lord, second marriage of the father.
Second marriage.
No, here is no, but sometimes happens.
No,
my
no,
lord.
but where is the second wife here?
No, there is no, my lord. But
We-
sometimes happen.
Yes, that is possible.
Ah.
But where is
So
the second
it is-
marriage?
Here, my lord, there is not
The
marriage.
mother is the same
There-
Sampatan.
He is the real mother, my father.
Mother is Sampatan.
And page 62, my lord, can you see?
62,
My lord.
73, that's 97. 97 voter list.
1997, my lord. My lord.
Sampatan is there.
Somebody mother, my lord, and my name is there, my lord, with my mother. That is 20, I was 21 years old.
Where are your brothers here?
In the meantime, they have got separated each other, my lord. They are residing separately. So many notice are issued to my family, to me, my wife, my children, from the family tribunal, my lord. But those are not decided, only my case decided, and I am found, my lord.
21 years,
Fine.
97.
And page 64, your kindly see, my lord.
Where have you stated that your brothers started to reside separately?
No, that statement, my lord, I have not found.
Huh?
In WS, my lord, that is not there, but deciding separately, that is true.
No, since in the 1985 voter list, you had two persons named
No, that-
Ghaznavi and Talibor,
At the time, they are separate.
who you are projecting to be your brothers, elder brothers. Now in 87, you come into the voter list, now 21-year-old,
Hmm.
but there is no mention of your brothers. But there is a mention of Sampatan. Sampatan is there.
Fine. And my lord, page 64, my name and my mother's name. Oh, sorry, my mother's name and my wife, my lord. And my name was in between, my lord, but that name was not given as because D was against my name. When
Hmm?
D is put, my lord, total list, my lord, certificate is not given against that name, my lord.
In 2010, your name is not there.
In 2010, my lord,
2010, you are not there.
not there.
Why?
Against my name, there was D.
D.
And D is, when D is put, my lord, that name is not given in certificate, my lord. As for my lord, that's kindly similar serial number 603605.
But interesting. The mother who was aged 74 years in 97, she becomes 73 in 2010. After 13 years, the age reduces by 1 year.
It is by 2 years. 2 years. It's 73.
And your name is not there.
No, my name,
Only one Rukia is there whose husband's name appear to be Samsul Haq. You are claiming yourself to be Samsul Haq, Rukia's husband.
no, I told you, not the D was against my name, so that copy was not given. But serial number is there, 6003 and 605. 604 was my, in that serial number, my name is there. but that number is not given. Copy. And Prince Miller 66, that is my brother and his wife. They are reduced.
66.
That was my brother. My lord.
This is of which year?
That is Miller 1989.
Labor. This is of somebody Talibor.
Yes.
Halil. Oh, open up. What do you have? Nine. See, this 1989 voter list, please do not rely upon this kind of things. It will be in your own problem, inviting problems for yourself. We kindly compare page 66 and page 60. 60 or 66.
Now, there is the Miller, my brother, not my lord.
Understood. But see what is wrong here.
My lord.
In 1985, your brother Talebar, projected brother, was 37 years. In 1989, he becomes 25 years.
Yes, brother.
After 4 years, his age reduces by 12 years.
Distance.
What kind of things are you having to reduce the age?
Again, Miller 19.
Mr. Payang, you should also get those things.
Yes.
Documents should have some kind of sanctity. You do not introduce documents like this. Some relevancy.
But one thing, Milord, here in the
Yes, 1 year, 2 years of age, even 3 years at times.
date
But
or year,
it cannot reduce.
the date or year, Milord, of the voter list entries, that is enumerator. Sometimes it is
No,
found.
no, Mr. Rashid.
But
You are
can
correct.
become me.
No, you are, Mr. We are not disputing this proposition. And mostly in voters list, there are inconsistencies. The 1 year, 2 years here and there, but a year, the age will not be reduced.
I admit, Milord, all this, Milord, I have seen also.
After 15 years, not to talk about increasing correspondingly, your age get reduced by 2 years. Your brother was 37 years in 1985. He becomes 25 years in 1989. If this 37 was consistent, there was no increase, matter would have been different, some wrong, some error.
And
This better. More or less. এটা না, বই ফেলবো tomorrow পিছে। না, যদি document জন তেওঁ rely কৰিছে, সেই document যদি তেওঁ support নকৰে, তেওঁ he has to face this kind of a question. যদি ৰিলাই নকৰিলেহেঁতেন ৰিলাই কৰিছে তাতে ইমান কৰি পাৰিছে।
দেউতাক মা ককাই তাৰ নিজৰ 21 আছে তাত সি 17
দেউতাক দেউতাক কেতিয়া মৰিলে এইটো নাজানো।
পুলি আছে একো দিয়া নাই চাগে সেই জনগণতি কপিখন দিলি
জগমন্দিৰখন চাওঁ ৰ'ব এখন।
নিমিলে জনগণতি আৰু চেল সেই খালীটো নিমিলে সেইটো মাটি ডেছক্ৰিপশ্যন
Yes, what are the rest of the documents? Let us
This
complete the
only
document.
Your Lordship, mechanic, you want, page Milot 79.
66 we have seen.
Hmm.
Then what else? 58, 1997.
My lord, 78 and 79. 78, Milot.
No, we see 60, page 69. We have not seen 69. Let's see what is page 69. Voter list of 1997.
My lord. It is my brother, Milot, so not
Talebor.
Talebor and Hamala.
Okay. Talebor is what? Two. 42.
42 years.
ক'তো বাঘবোৰটো লিখোতে এনেকে ক্ষয় হ'ব সেইটো প্ৰব্লেম নাই কোনো বস্তুৱে হ'ব Dear works in this month 59 not 25 57 54 27 Yes, then
Then Milot, page Milot 78.
what is 72, 71?
20 Milot, land purchased by father.
No, say page 70.
70 Milot, sorry. 70 is the voter list of my brother, Milot, and his family.
2010.
2010, yes. A village same Milot and house number 343. And in the name of my brother is there and my brother's wife and his son.
But these are not going to have any
No relevance.
no connection.
No,
We are not connected with your brother. What is page 72?
Page 72 Milot, my father purchased land Milot. Land deed. Intensive 11%. But vernacular Milot not eligible.
What is the date?
Date was Milot 3/2/1981.
Registered sale deed.
Yes, my lord. 73 Milot, seals are there, but not legal. And it was exhibited, Milot.
Now here, what is the description of the land? Schedule is there.
Schedule Milot. Schedule is there. District Bapota, PS Bagbor, Mauza Mondia, Village, Velar Palm, Kiraji Patta number Miller 144, bag number 18. There is I have studied my page 72 and bag number below Milot. Bag number 18, land measuring 1 katha 15 lessa out of 6 katha 6 lessa.
What is 75?
77.
Khazna,
Yes, sir. Khazna Rashid.
76.
There is a money receipt, revenue receipt. 77.
But this patta number is different. Your patta number is 144.
It is different land, Milot.
এই পাতা নম্বরটা 144 এর পাতা বলে একটা নম্বর আছে আপনার রিসিট খান tag is 18 even
Here in separate land ready.
here the tag there is no mention of the tag but a pata is there in the column tag to নাই tag ঠিক বলেছি তো tag নাই পারো tag ঠিক বলেছি আসলে এক্সনা খাজনা স্থানীয় কর And in any case, this was received from Ghaznavi
Ghazni.
and one more, Talebor. Ghaznavi and Talebor.
Which
What is the date of this Khazna?
has not date Milot, that is
1/12/2010.
Yes, 1/12/2010.
1/12/2010.
My lord.
If you are born in 80, why your name is not there? Purus.
Now my name is there, Milot.
Samsul.
Samsul, my name is there. There, Milot, Ghaznavi, my brother, Taliban, my brother, and Samsul is my brother. My father is not there, Milot.
But this land is a different land.
This is Milot, Medipata number 112.
Yes, the land which your father had purchased in 1981, KP Patta was Khedas periodic was 144.
144.
Dag number 18.
18. And here in Milot, Medipata number 112.
112, 119, and 84.
Maybe Milot separate land, they have
84 is different.
different land.
Agamoni is 112, 119. What is this 79 page?
78 Milot.
Yes.
78 Milot, that is Zamabandi.
Ramamandi.
My lord.
As per dated to code Dag muted name of Samsul. This is 402 and 403 Dag number.
My lord. 402, 403 land.
The
located-
father's property was Dag 18.
As per the order dated, Milot, as per dated 2/3/2011 of bag number 100. Yes, that's. And my father name is kindly see page 78 and serial number and mention 7. In particular is there, Milot, 7 is here. Page 80, serial number 7, my lord. Name of my father is Ghatu Miya, there is there, my lord, yes. He was Pattabhar in that time.
This is explaining. This is 112.
খাজানা দিয়া
এইটো মাজতো দেখো বাৰু কিন্তু কিনিছিলে হেৰি 100 দাগ নেকি না দাগ পাত্তা 144 আছে কিন্তু সাত নম্বৰটো ঘটো 30 নম্বৰটো এই নেকি 30 নম্বৰটো শামসুল হেৰি কেইটা নাম কোড কৰো এই In this Jamabandi, where are the names of your brothers?
Brothers, my lord, yes. Brother's name, my lord.
Because your name, if you come to page
My name appeared in serial number 30, page 82.
page 82 on
page
the right
82.
on the right side,
Yes.
you please read Sithar Sapra Bikhar so Ingrazi Tariq Hukum Morme Mote Uttar Sutra Pattar
Sitar Sakro
Sarihot 2 Sarihot 3 number
11
Dag number so Patadar Solot
long
Samsul Haq.
Hatnong earlier was 7 number was my father, and in his place my name, Samsul.
Where are the names of your brothers?
I was also searching the same, my lord. Yes, your lordship. Only his name. Their names are not there, my lord. Only his name, my name is there and in place of my father. Yes.
Bye. Yes.
Anything else? We have seen the Gaumbura certificate at page
No, that is
85.
not national emblem is there. So only oral statement your lordship may consider, but his certificate as because High Court judgment is there, national emblem is there, so that may not be. But his statement is there. He knows him.
Mr. Payang, just to think aloud, the use of national emblem is not allowed. But will the contents will go as a whole because of use of national emblem? That is not the, you cannot read this judgment in this manner. You are
No,
not
that-
authorized to use the national emblem.
There-
You have to ignore that.
Definitely, my
And that
lord.
will not give any further sanctity to the certificate. Certificate has to be read as a standalone document.
Yes.
Hence the national emblem. But only because of use of national emblem, the contents also goes. I don't think that is a correct proposition.
And the probably this on my lord, on this honorable court has settled that position only that aspect that document is not admissible. The document is not admissible in that manner.
But
No, can it be the proposition? You use a national emblem,
Yes,
which you are not authorized.
yes.
So that part you can criticize, condemn. But what about the contents of the documents?
Contents also there has to prove by.
Contents
bringing
have to be proved.
Entrepreneur's
So
record.
what we are saying, it's
Two
not that
aspects,
content
my-
will automatically be proved or automatically be disproved.
Yes,
The burden will still be there.
yes.
But it is not the case because national emblem have you are not going to see the document at all. We'll see this document.
Yes. my lord,
But use of national emblem will not add to the veracity or authenticity of the document. That you can argue, but
authenticity of the document is my lord,
has to be
yes, yes.
in accordance with law.
Contents probably my lord, contents whether that is correct or not, that may be different aspect.
Yes,
But
that's to be
the
proved.
document itself is not admissible because of using of the document.
but statement evidence which is deposed in the court, that also your lordship may be pleased to consider.
Then Gaubra statement has to be taken as oral statement. Yes.
Fine, fine. लिखी दे क्वेश्चन में दे प्रोग्राम क्वेश्चन
Yes, anything else, Mr. Rashid?
before Rashid, though there is some wrong entries in the age of the voter list, but it is true that the name of his father and mother, there is no dispute. There is no any question regarding the voter list in the cross question, cross examination. And as because his name is rightly entered in the voter list with his father, and father's name is there, and his name appeared with his mother, and rightly casted both also. And Gaurav also stated that he is the local person, he knew him. Apart from certificate, I personally know. And his brother also similar, though they are the two brothers, but they are as because thumb branded person, so their names.
Well, let us see the evidence of the Gaumbura. Gaumbura deposed as what? DW.
DW 2 Miller, page 22.
Page 22.
Right, Mr. Married Miller. Since 1975 till date, I know the OP Shamsul Haq.
Yes.
My name is Hazrat Ali, Gagura Minute. Deposition note. When I am government Gagura of village, when I am governor of village Agmandia, second hero from since 1975 till date, I know the OP Shamsul Haq. I have issued certificate to him as a resident, as present resident of village Agmandia, and the son of late Gatumia. Exhibit P is the said certificate on 23 to 15 as a resident of village when I am the Gagura. The OP is not a foreigner, he is an Indian citizen as per my knowledge since I know him from childhood. Primary ask question, primary student. We maintain registered book for issuing residential certificate. We do not keep population registered book. I have not brought and submit any document of the population inhabitants of the both village Agmondia and Bhairab. The OP may about a 40 years old on present date. The OP's father had expired 20 years ago. I do not remember the date of death, his death. During his lifetime, he had casted vote. After 1985, as I know he had not casted vote. The OP has two elder brothers. Both are maybe 50 years old as on date. I do not know their age. Kevin said the both are maybe 50 years old. I am saying his right of age. Exhibit T is my identity card. Yes.
Yes.
From his statement, it is implied that he is a son of Ghatunga. There is no dispute. And only dispute regarding age. Age and as a little person, this happens. And there is a record with his name and his father's name.
Okay, Mr. Pang. Any decision you'd like to cite?
The decision must.
No, I have not bring but one decision that is, I have not bring, but people were stripped.
Okay, Mr. Pang.
Yes. The entire case here, best. If your lordship may see the WS first, my lord. And evidence. Page 11, my lord. Page 11 is the WS, my lord. The pleaded case of the petitioner is that, my lord, the father and mother's name were there in 1966. And then 1970, page 6, para 6-7. And para 8, my lord, voter list of 1985. Relied on voter list of 1985.
Yes.
Then para 9, it is voter, they said about my lord 1997 voter list.
Yes.
Then 11, my lord, described about 2010 voter list.
Yes.
Then para 13, Gavura certificate.
Yes.
My point is, my lord, the petitioner has not stated anywhere whether he has any brother or not. That is absolutely missing because he relied on 1985 voter list at para 18, my lord, but he is silent about his brother. Intentionally silent. And he said that is very important because the discrepancy is obvious in consideration of my lord evidence. Even in evidence also, filing evidence, if your lordship will find evidence at page 16, my lord. Evidence also he is silent, totally silent about his brother. And he has not given any explanation why these is discrepancies, views is discrepancies of the father and mother. No explanation at all. And
Yes.
And my lord, he has relied on the land document, saying that his father, he has inherited the land of father. I'm not going, my lord, before going to the merit of the document, my lord, he has not stated anything about in the WS, nor in WS, neither in WS, nor in the my lord evidence about any land possessed by him or his father was possessing anything about the land.
No,
But
no. Then that, how was that exhibited?
that is exhibited, my lord, in the last moment.
No, no. It was not, wasn't it mentioned in the affidavit in the?
No, no, it is not mentioned in affidavit.
No, no, chief examination?
No, no, nothing.
How was it introduced?
It was brought later on by someone else.
Hmm?
It was not brought by him. It was brought by Hmm?
Brother.
Not even by brother, my lord.
Then,
Brother's evidence is page 25, my lord. Talebur Rahman.
okay. Latmandal.
Yes, Lat Mondal has brought documents. The land documents brother has said, my lord. Page 27, land documents, that my father have landed property, one land registered it executed my father so and so, and negotiated so and so, so and so, so and so.
And who exhibited this?
Jamabandi was not brought by him.
No, who exhibited the Jamabandi?
Jamabandi probably by the Latmandal, my lord.
And Khazna receipt? Registered sale deed?
Registered sale deed was by probably my lord, by DW, the brother, my lord. Talebur. Now this Talebur was not introduced in the neither in the WS nor in the evidence, my lord.
DW3.
DW3. And as your lordship seen, my lord, apart from discrepancies are there. Apart from the discrepancies of age.
Khazna is also by Talebur?
Yes. Patta is not.
No, Khazna.
No. Patta is not by Talebur.
Khazna by page 76? Khazna would be by Talebur. Who else would have the possession of these Khazna receipts?
Certificate. Then rest. DW3, my lord, he brought. That is the,
Alibor only?
yes, yes, yes. Para 24 of the judgment opinion, my lord, the tribunal has taken consideration. Beside this, the document neither exhibited by OP nor by DW3. These were not exhibited, my lord. Without taking leave of this tribunal, out of nowhere, these documents were filed.
Which paragraph?
Para 24, page 49.
Page?
Page 49. From para 43 onwards, it is said, however, OP had again taken assistance of a Lat Mandal of Pagpur Avenue Circle, Mandia, by summoning him to prove a Jamabandi copy, that is Exhibit Z. But about this document, neither OP nor DW3 had mentioned in their respective affidavit. OP had not pleaded about the land property or be inherited, own or possessed any village in Parpeta district. Besides this, the document neither exhibited by OP nor by DW3. Without taking leave of this court or leave of this tribunal, out of nowhere this document was filed. From the order sheet of the instant case, it is founded by petition number so-and-so on so-and-so. OP had prayed before the tribunal to pass an order for taking a step to summon the Lat Mandal and election officer to prove the land document, and the voters list relied by OP. In the said petition, OP had not made any specific mention about the land document for which the Lat Mandal was to be examined. However, for the ends of justice, the prayer was allowed, and accordingly, OP had examined DW4, that is the Lat Mandal. So these documents were not. So these pleadings were not there. The important fact, my lord, as your lordship have pointed out, in WS he has said his father died before 1997. In evidence, he said my father died after 1985. After 1985, before 1987. It's surprising, my lord, it is the personal knowledge, my lord. Nobody can know other than the petitioner when his father died. They have picked up some documents. They pick up these documents, and after reading the documents, they found that this person is missing from this period to this period. So they have given a vague statement. My father died during this period from 1985 to 1997. Now, if you see the land documents, even till date, my lord, the father's name has not been struck out. The Jamabandi copy, father name has not been struck out. And other brothers are not there in the my lord. And that land is not the same land.
The different land.
Different land. And other brothers are not there.
But so far as the petitioner is concerned, the projected petitioner is concerned, in the Jamabandi name,
Yes.
there is a reference that as an inheritor, his land has devolved upon him.
Yes, mother. His name has been inherited as per the of
Uttor
notated.
Dhikari Hutre.
Yes,
That is the mention.
2/3/2011.
11.
Yes. As per order of the 2/3/2011, শামসুল হক পিতা ঘাটমিয়ার নাম নামজারি করা হয়। উত্তৰাধিকাৰী সূত্ৰে পত্ৰা 402-403 নং দাগৰ 4 নং পত্ৰাদাৰৰ স্থলত শামসুল হক পিতা ঘাটু মিয়াৰ নাম নামজাৰি কৰা হয়। If, my lord, the petitioner's name has been inserted in place of Khatu Miya, Khatu Miya's name should have been struck. When did Khatu Miya die?
No, at times the striking off may not have too much of a relevance. At times they forget to strike off. But the principal issue which you have raised, or we have also noticed, that the land is a different.
Land is a different land. when the purchased land is a different, this land is a different. And
Now,
it is
whether
a-
this Khatumia is the same
Same or
Khatumia
not,
who
that
was
is
been
also-
projected to be the petitioner,
Yes.
that is not
That is not.
established at all.
Secondly, my lord, how this Khatumia entered to this land? When he got this land, this plot of land, where the name of the petitioner is included, that is not there in the my lord noting. Nowhere it is there. I have checked it out in the entire noting. How this Khatumia got this land, when got this land, that is not there. So only one my lord, noting is there in 2003. 2003, my lord. One one Abdul A. Hamed was, my lord, included as Pattadar along with Khatumia by way of purchase in 2003. One my lord, A. Ahmed's name has been included in 2003 as by way of purchasing the
Which
land
year?
in 2003, my lord. This is by noting dated 31/12/2003.
Could not have been because
Yes.
he registered the sale deed is of 1981.
No, my lord.
Well, it
Yes.
was in the sole name of the Khatumia. There was no two co-purchaser.
Yes.
So this is not consistent with the
This
registered sale.
registered sale.
Is 73.
And probably, my lord, if the statement of the petitioner is correct, the Khatumia might have died prior to 1997. That is also another. Whatever, my lord, but this document, my lord, this document shows the document, my lord, his name included in this document only in 2011. So this is a post-71 document. There is no evidence that, my lord, this land was possessed by him prior to 1971, or father was possessing the land projected, father was possessing the same land prior to 1971. And that Khatumia, who had a registered sale in 1972, and this Khatumia is same and one person owner, because land is different land. Admittedly, lands are different land. Even the village is also different. Village is also different. If your lordship may kindly see the sale deed, the extract of the sale deed, it is there in the schedule. The village is village Bahirar Pump. Not only the Tag and Patta, village is Bahirar Pump. Bahirar Pump. And it is, the village is Akmondia, the Jamabandi of page 79. So this is of a different village.
Agmundia is my residential address, Agmundia.
No,
But
land
Land may be
is different. That's
And-
why.
And there is
So
no,
that was-
your lordship knows me, there is a revenue village. When in land millard is always used as a revenue village.
No, both
And in
both are
this
land
one I am
documents
saying-
only. That's why I'm saying both are land documents. So it should mention on the revenue villages. Either in the sale deed or in the Malad in the Jamabandi. It should mention the revenue village only. So revenue villages are different in both the land documents. That is the point. And that's why, my lord, everything has been discussed in the opinion. It's nicely discussed A to Z, my lord. Not a single word is left out. Everything is discussed in the just opinion. And I think, my lord, there is no error or there is no scope of interference of this opinion, my lord. I'd like to rely on one judgment, my lord. The, my lord, relevant facts, the material facts has to be pleaded in the evidence. And only those material evidence, material facts which are pleaded in the evidence, that can be proved in the evidence, not beyond that. In this judgment, it is, my lord, clearly said, 2017 2 GLT 1076. 2017 2 GLT 1076. Momin Ali There in paragraph 12 and 13, my lord. This clearly said. 13 only I like to read out. It is settled proposition of law that when a party fails to set up a case in his pleading, he would be debarred from adducing evidence in his support at the stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. So in the pleadings, he has not disclosed about his brother, but he brought him as a witness. He did not disclose about my lord, land. That apart, he brought the land documents, and so this cannot be allowed. So and with regard to Gaobura has given a certificate, my lord, as your lordship has seen already. That admittedly the Gaobura has put the national emblem. So make the document inadmissible for the purpose, my lord. Even though, my lord, if we accept the oral, if we see the oral part of the evidence, now the documentary evidence has to be proved by, cannot be proved by oral evidence. It has to be proved on the basis of contemporaneous record. He has not brought any contemporaneous record.
No, here there is some difference with this case.
Yes.
See, there is no two views on the proposition that a certificate, if it is given by a particular authority, then he needs to prove that certificate on
Yes.
the basis of contemporaneous record. Now here, apart from the certificate,
If we see the
Gaobura
oral evidence, my lord.
says, no, he gives oral evidence. Okay, Gaobura is himself 75 years of age. He has said that I know this person from his childhood.
Yes,
So these are evidence from the personal knowledge.
personal knowledge.
In a given case, a person who is your neighbor, who knows you from the date of your birth, he can come to the deposition box and say, for that you do not require a
Certificate.
or any document.
Yes, that is.
Of course, his version would be subjected to cross-examination, whether he is speaking the truth. But in case of a Gaobura, who has been the Gaobura since the date of his birth, his oral evidence would stand on a higher footing than a Gaobura who has been appointed subsequently and he deposes on the basis of certain records.
Yes.
And he gives the certificate. I have checked the records, given the certificate.
Yes.
On the date of the evidence, I did not bring the record. Yes, inconsistency.
Yes.
But this Gaobura says that I know him from his childhood.
Yes.
We have checked that.
Uh,
So in all cases, you cannot put all the cases in the same basket.
That is.
There may be some difference.
Yes, definitely, my lord. But, my lord, that's why I'm saying, my lord, the certificate, if we ignore the certificate, then we cannot say that the certificate has to be proved by contemporaneous record, because we are ignoring the certificate, my lord. So it is not, that proposition may not come.
Yes.
Now, his evidence will be taken as a oral evidence
evidence.
as any other person, my lord.
Yes.
Not as a Gaobura only. His evidence will be taken as a oral evidence as any other person. Now, this High Court has settled, my lord, the oral evidence in foreigner's case will not be acceptable if there is no documentary evidence. So that also, in that case
That
also,
was said in what context?
that was in, even the father, my lord, even the father came, father has said he is my son. In that case also, it would be not acceptable if there is no link document. If there is no link document, even if mother comes also, my lord, mother also her evidence cannot be accepted. In that case, if there is no linkage documents between mother and the son.
In foreigner's case.
In foreigner's case. So, and in Vijay Das, it is said that oral evidence in any case cannot be accepted in the foreigner's case.
Vijay Das has been referred in the
Yes, the number
impugned
six.
opinion.
Yes, yes.
This opinion has referred Vijay Das.
Yes, opinion has referred. Please, another full judgment, madam, like where this is 2023 GLT 347, madam.
2020
3 GLT 347.
name
Name is my lord Noor Begum.
and NUR
NURBEGUM Begum. There it is the testimony of DW3, that is Zahira Begum, who mother, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather or to the petitioner himself. Oral testimony of DW2 alone any documentary support cannot be treated as sufficient to prove the linkage or help the cause of the petitioner. That is in para 6 of the judgment, my lord. And in another case, that is in further case, my lord. This is WPC 4020/2017, my lord.
Noor Begum, what is the proposition?
Proposition the even though mother it gives evidence, my lord, if there is no linking documents, that cannot be only on the basis of oral evidence, it cannot be accepted, my lord.
Yes.
In another that case also, in another case, Asia Khatun 4020/2017, there the father came where it is said
WPC
4020/2017,
2007.
my lord. Asia Khatun. ASIA KSA T11. There the father came, my lord, where the same proposition was settled, even though father gives evidence, but if there is no linkage documents with the father in the petitioner, that cannot be accepted as evidence for the purpose of citizenship.
Yes.
And Bijoy Das has clearly said that in any case, my lord, oral
Because
evidence.
is reported.
Yes, reported. This is 2018 3 GLT, my lord. Bijoy Das. 2018 3 GLT 118.
2018. 3 GLP
118.
118.
Now, all this on my lord, the mere fact, my lord, only even on the, my lord, for a prudent person, whether the proposition, whether the, my lord, the narration given by the petitioner can be correct or not. For a prudent person, my lord, even my lord, this can be the cases where, my lord, the person who may come after 1971 adopted someone as father or mother, but not his original father or mother. That can be the situation, because the difference between, my lord, age of siblings of the projected two brothers and the petitioner is at about, my lord, 30 to 35 years, and there is no other person in between. And he could not say when did father died. On the basis of some, my lord, document, relying on the document, he is saying that my father died in between this period. And intentionally did not disclose the brother's, my lord, name. So all these things, and without explanation of all these things, my lord, the tribunal cannot presume, my lord, that there can be something in between this. So they may be a brothers or sister, and this may be correct. The presumption cannot be drawn by the petitioner if no explanation is given. Has there been any explanation why this is discrepancies? Why this use as discrepancies between brothers and the petitioner? Then, my lord, it could have been some extent understood. So therefore, my lord, my humble submission is the tribunal has not committed no wrong in passing this opinion. So this may not be interfered, my humble submission. And as your lordship knows, my lord, the Supreme Court has settled in certiorari jurisdiction. That is there, my lord, always. We may not interfere.
Okay.
Only, my lord, my own submission regarding the linkage. Jamabandi, my lord, it was proved by the issuing authority and also, my lord,
But the Jamabandi is not pertaining to the land which your projected father had purchased.
but it is the Pattadar, my lord. He is the Pattadar. Father is the Pattadar, my lord, of the land.
Now, how do you
And
link the Jamabandi with the registered sale deed which you had?
No,
proved?
yeah, you should be right. I'm not saying that this land is that land. There is several land, father purchased, and mutation, my lord, in another land.
Then the question,
And where I am residing.
now the question which will arise, where are your brothers?
This land is given to me only, my lord. That is
No, by inheritance, not gifted.
not every inheritance.
By inheritance, if it is by inheritance, there are two brothers.
Yes.
It is not the case that brothers have passed away. In fact, one of your projected brother has deposed as DW3.
And there is a, from the.
Okay, we'll
state
consider.
only it is clear, my lord.
We'll consider.
Linkage.
We'll consider. Okay.
And voter list, my lord, was 6670. There is no any dispute regarding voter list. This is clear, my lord. And in my lord, cross examination in the tribunal, my lord, your lordship has seen, my lord, probably. There is no any relevant question regarding voter list. And what are the questions, my lord, your lordship may see, my lord?
So voter list we have considered.
Consider, yes.
The lack of pleadings.
Some lag is there.
No,
my lord.
if you do not mention that you had a brother and brother does not come to depose, matter would have been different. Now one person comes to depose. There is not even a single reference or mention about such a person in your entire WS. Okay, in your deposition as DW1, you did not mention about brother.
Brother.
You could have mentioned about the land. Land could have been proved by somebody else, but there is no mention at all. Let us see.
Right.
কালাৰটো এইটোতো এপ্লিকেশ্যনৰ হ'ল না কমেণ্টৰ এইটো আৰু এই কলাখিনিহে গ'লে আৰু এটা বেলেগ তেতিয়া আপোনাৰ এই ফাইণ্ডিংটো সোমাই দিব পাহৰি নাযায় এতিয়া মই এতিয়া যে লিখি এইখিনি মই সোমাই দিম মানে সুবিধা হয় আৰু বহুত মই যি কৰোঁ যি বুলি নহয়
to quote বা question answer দিও আপুনি যেতিয়া সোধে তাকে বেছি ইংলিশ
red, black, blue, ৰাখিব তিনিটা মই পঢ়িব এতিয়া বুলি নহয় মই উকালতিটো কৰিছিলো আদাৰ আৰ্গুমেণ্ট বেলেগ এটা আৰু মোৰ জবাববিলাক বেলেগ কিবা তাপত বনাই থৈ দিম অ'কে পেজবিলাক লিখে নে লিংক আপ কৰিব কাৰণে পেজ লিখে ক'ত লিখে পেজ নহয় এই চাইডত পেজ লিখিব চবতে পেজ আছে লগ দিলে বুলি কয় এইটো হলে কি ইজি হৈ যায় আৰু Yes, next.
Base is 60 to not secret. Maybe page is different. 60 to
That case of my type is this. Yes, Mr. Google.
Page 60 to my lord. Due to non-available documents, my lord.
Yes.
My lord, due to non-availability of documents at the time, my lord, the written statement as well as evidence with documents, my lord, could not file, could not produce before the alternative judgment.
You did not even file written statement.
My lord,
Did you file written statement?
written statement filed, but without any documents, my lord. So because
Evidence? What about the evidence?
so, my lord, I may be given an opportunity, my lord, to file the written statement and evidence before the alternative judgment.
If you have to look into the case, cannot be for granted. Let us see. Your JC Gogoi,
My lord,
Mr. Sharma will be appearing.
Yes, Lord.
And Ali. In the earlier case, election commission was not there. There. You were there in the earlier case.
Yes, sir.
so
Photo of this. Provision towards examination. Therefore, the proportion. Oh, see, it was horrible. Couldn't even like it. Certificate copy applied on 5/4 of the voter list, that is after the second final opinion. Second 24 to DCLFI. Evidence of petition of evaluation cannot be an ambulance exercise. Is that sufficient to proceed? Sarijan dekhate. It's other duty provisions. Right. Yes.
Lordship, can I take this second file, Lordship, for the time?
Second copy you cannot give.
Lordship,
How can you ask for a second copy in a
Lordship,
DB?
Lordship, sorry, Lordship, sorry,
Make that kind of audacity.
Lordship.
Say, we can give a part with the records, see the records.
Yes, record, I think. Record is not here.
Records will not be necessary. You listen to your colleague. What
Yes,
is
Lord.
it? Yes, what is your case?
my lord,
What is your case? Let us see look into the impugned opinion.
yes, my lord.
Nothing.
I could not prove this case, my lord.
Huh?
I could not prove this case because of non-availability of
Well,
documents.
we
I
will
could
have
not
to see.
present. If an opportunity is granted, my lord, ladies, my lord. Yes.
Opinion to take, you know.
Definitely, 24 to 2023, my lord. Case 65.
Second case of,
Lovers will come on the
Okay, time of the night.
Engage council. Yes. For example,
No. También que ver dot D.
এটা আছে এটা নাই এটা কি আছে না
এইটো নহয়, এইটো part আমি discuss কৰিম।
এটা অর্ডার কৈ লাভ নাই নিজে কৰিব লাগিব কোনো মানে নিজৰ জুচি নিজে নুমাইছিলে মুখত ভৰাই তেনেকে নুমাই নিদিয়ে
Yes, where is the opinion?
62 মাইল
Page
62
62,
62 মাইল
please. What is the date, Mr. Gogoi?
24 to 2023 ফাইনাল অর্ডার for 2023
Please read.
মাইল
Please read. He had appeared.
Here is the CR matter. From this year, it appears that the OP has been grossly neglecting opportunities granted to him for filing his documents in support of his case since the filing of WS on 17/11/2020.
24,
Unless
12,
and
19,
until
this issue.
documents in origin in support of his claims, no pleadings in WS are filed by the OP in this case. His WS alone cannot prove his case. Order 3+8 of the Foreigners Tribunal or 1964 mandate. The Foreigners Tribunal shall give the proceeding 10 days time to give reply to the show cause notice and further 10 days time to produce evidence in support of his case, of his or her case. Order 3:12 of the Foreigners Tribunal's Order 1964 provides the Foreigners Tribunal may grant endowment of the case on any plea, sparingly, and for reasons to be recorded in writing. Order 3/14. The Foreigners Tribunal Order 1964 mandates the Foreigners Tribunal shall dispose of the case within a period of 60 days of the receipt of the reference from the competent authority. In view of and in compliance with the mandate by the orders, I hold and give my opinion that the OP in this case, namely Mohammed Akramul Hussain's from Idris Ali the village, Dikar Mukh, Tapat Juri under Daboga police station in the district of Khoja, Assam is a foreigner who legally entered into the territory of India, Assam, on or Assam, or on or after 25/3/1971.
You had come to this court earlier
My lord,
against the first order.
earlier, my lord.
First order was passed on 6/12/2021.
Yes, my lord.
That was the subject matter of challenge in WPC 5122 of 2022.
My lord,
High Court passed an order on 10/8/2022 setting aside.
my lord.
Then thereafter, 1, 2, 3, 4, 5, 6, 7 dates given.
Yes. My lord, my engaged counsel was interested for obtaining the certified copies of the relevant documents, my lord. In this regard, my lord, complaint will be lodged before the Noga Bar Association.
Bar Association,
Bar Association, my lord.
what will the association do with his practice? Will not allow the council to sit in the bar maximum
But
or use the
60
bar facilities.
Yes, my lord. Base 60, my lord.
He'll have his chamber in his vehicle. He'll buy a Maruti van. Mobile chamber.
Mm.
We thought you had some case.
My lord.
The more we entered into the brief, the more we are convinced that you do not have anything at all.
Kindly consider, my lord.
No, it was considered
Mm.
by this court in the first round itself
My lord.
in the year 2022. Thereafter, 7 dates. You did nothing.
No, without my documents, my lord, how can I?
Now, where will the document now arise? From where? Heaven? It will fall from the heaven.
Not at all, my lord. He's an illiterate person, my lord.
You will not become literate today. Have you become literate today? 3 years you have started studying, reading. Position is still there. You have neglected, Mr. Gogoi. If you neglect like this, how will the Code of Equity help you? Gross negligence cannot be more gross than this.
My name appeared in the photo list of 2005, my lord.
You have some documents, have you enclosed here?
My lord, yes.
Where? Page
My lord, page 37, my lord.
37.
My lord. Serial number 538.
37. Voter list of which year?
2005, my lord.
2005. What is your age?
20, my lord. Serial number 538.
Serial number?
538. 538.
What is the name of your father?
Idris Ali.
Huh?
Idris Ali.
Idris. Let us see where is Idris Ali. His voters list. Idris. In that period where we are concerned.
Page 31, my lord. 29 also there, my lord. 29 and 31.
We cannot allow you this. See, first, you were declared a foreigner. Why an order dated 6/12/2021. That was the subject matter of challenge in a writ proceeding 5122 of 2022. Okay? That writ proceeding was decided in your favor on 18/8/2022 and the matter was remanded back.
My lord.
7 dates were given. He did not do anything. Now the second opinion has come on 24/2/2022. 2,
23.
2023.
Yes.
Please mind the date, 24 to 2023. And if you come to page 25, Mr. Sharma,
Lordship.
the certified copy has been applied on 5/4/2023.
Yes, Lordship, after.
After the second opinion.
Yes, Lordship.
No, there is a communication gap between the lawyer and the petitioner, my lord.
Where have you stated?
Letter is available. No,
Let's see. What communication gap? Who was your lawyer?
PT doctor,
Huh?
PT doctor. At page 30, my lord. Kindly come to page.
Page 30.
Yes, madam.
No, where in the pleadings? High Court pleadings. Where have you stated?
Page 12, my lord.
12.
13 and 14 para.
Name of the council?
PT doctor.
Where have you stated?
I have not stated only I have mentioned, my lord.
You have not even given the name of the council. Let us see the complaint,
My lord.
page
Page 60, my lord, 60,
60.
my lord.
Nagaon Bar Association.
My lord.
Everything has been done after second opinion, Lordship. Yeah, that's it. Second look value. Last of it.
You cannot go beyond the High Court's order. Come to page 59. Page 59. In the first round of the writ petition, it was disposed of on 18/2/2022. Come to page 58, paragraph 11. While the remand was being made, please read, Mr. Gogoi.
The petitioner shall appear before the London member for an appeal substance. Naga at Sangadev Nagar, Hosea, Assam on 31/8/2022, along with a certified copy of this order, and shall submit the relevant documents before the concerned tribunal, subject to payment of rupees 2,500 only to the District Legal Services Authority. Hosea, in the event of producing any such documents and evidence as directed above, the learned tribunal, after considering them, shall proceed with the matter in accordance with law and shall pass an opinion afresh. Needless to say, in the event of failure on the part of the petitioner to appear before the concerned tribunal on 31/8/2022, and on the subsequent dates as may be fixed by the said tribunal, the said authority shall be at liberty to pass necessary orders as per law.
See, the first round
Now,
of writ petition, which was concerning the first order dated 6/12/2021, had culminated in this order of 10/8/2022, correct? And in that order, date was fixed on 31/8/2022 for appearance. Thereafter, 7 dates given. And what is more surprising and shocking is that after the second opinion, which is the present subject matter of challenge, namely 24/2/2023, you apply for certified copy in April 2023. You will not a fitness, not at all. Not at all. Yes, Mr. Sharma, would you like to say anything?
Lordship, only two judgment, Lordship.
Izzat Ali.
Izzat Ali, Lordship,
Sarizan Nessa.
and WPC 291 of 2025.
What
All
is that?
291 of 2024. Baharul Islam, BAHRUL,
What is that?
ISLM. Regarding all these things has been discussed, Lordship, regarding Izzat Ali.
What about Sadar Ali?
Lordship,
8489 of 19? Decided on 31/8/2020. I think Sadar Ali will also cover.
Lordship, I have
Check
not done
this,
so.
check this WPC, please note it down.
Hmm.
WPC 8489 of 2019.
848.
Dated, decided on 31, this is 31 or 21, 31/8/20.
31/8/20.
21st
8489
of
of 20.
August 20. Sadar Ali, SADR. What is your citation? The other one?
Other
Bahar
one
Ali?
is Lordship, Ayub Ali, Lordship.
No, you said Bahar Ali or something.
2016 to GLJ 375.
Name.
Ayub Ali.
No, you have just said Bahar Ali.
No, Baharul Islam, Lordship.
Yes,
Baharul Islam.
What is that?
291 of 2024. All aspects has been discussed.
WPC
291 of 2024.
Baharul Islam.
Yes, Lordship.
The date of the judgment?
Lordship, 23 to 2024.
Okay. And the other one, Ayub Ali, what is there?
Yes, Lordship. 2016 to GLJ 375.
What is there?
Same thing, Lordship. Regarding. And Ayub Ali also discussed in this judgment, Lordship, Baharul Islam.
Okay. Okay, reserve for later. But we are going to dismiss this.
Lordship.
Reserve for.
Published.
There's no scope at all.
Yes.
We thought there is some scope. আৰু এখন কাগজ আছে নেকি পুৰণি কাগজখন ইমান নাই ইয়াতে থলো ইয়াতে দিয়ে এখন পাই এখন মোৰ এইখন ইয়াতে দিলে সেইখন খাওঁ মোৰখন ইয়াতে দিলে ভিতৰতে Judgment ভিতরে আছে, opinion opinion ভিতরে একদম ভিতর page 62 এখান থেকে উঠে I got it.
Obliged.
May I please, your lordship?
Yes.
The impugn order at page number 69, Annex 15, lordship. Impugn order passed on 29/9/2023, lordship.
Notice has been issued.
Lordship.
Notice has not been issued.
Not issued,
Okay.
lordship.
We have to issue notice there, okay. Okay, heard. You are, B. Boragohai.
B. Borgohain, lordship.
Heard Sri B. Boragohai Learned Counsel for the petitioner who has put to challenge an opinion dated 29/9/2023
Lordship.
passed by the learned so-and-so in so-and-so, by which the petitioner has been declared a foreigner post 24/3/1971. It is the case of the petitioner that the relevant documents, including the voter list of 1966 of the grandfather and that of the year 1971 of the father of the petitioner, were not properly considered. Where that notice be issued, returnable by 6 weeks. Union of India. Asil Sri G. Pegu, CGC, then Home Department G. Sharma, 2,
5, 6,
2, 5,
5 and 6.
6. A.I. Ali for response number 3. And District Commissioner P. Sharma. Okay. Extra copies be served upon them within 2 working days. Para. Sri Borgohain, the Learned Counsel prays for an interim order. Para. Considering the facts and circumstances, it is directed that till the returnable date, no steps for deportation of the petitioner be taken.
Much obliged.
You take steps, serve extra copies.
Lordship.
May I please, your lord, we kindly calculate the time being, my lord.
Time being, why time being?
Is in 16, my lord. Is a court number 16.
Motion, what is the opinion about? 22, will issue notice for petition.
Or my lord can issue a note.
Same order will pass. Okay, what is your name? You are there in the matter or
Yes,
not?
yes, Ahmed.
Huh?
Yes, Ahmed.
Yes?
Ahmed.
Okay. What Mr. Roy Chaudhary would like to come?
Yes, yes.
Let him come at 2 o'clock then. We'll reach, sit at 2 o'clock. Yes.
Obliged.
I'll get to reach out to his number. তেওঁৰ নামটো ৰেকৰ্ড কৰিও দি দিব পাৰিলে হ'ব বাৰু পিছত
May I pray for application of item number 22, madam? Yeah. Entire list matter, madam, this is only habeas corpus matter, madam.
let us see. Yes, next.
May I please, your lordship, I am sorry, but I went to the acclimation ground. Notice may be issued, Malak, in this.
We wanted to issue, but he was insisting in our presence. We also thought that we'd like to be present. Heard this item number 8. Heard P.K. Roy Chaudhary, Learned Counsel for the petitioner, who by means of this petition filed under Article 226 of the Constitution of India has put to challenge an opinion dated 30/3/2024 passed by the learned so-and-so tribunal in so-and-so case, by which the petitioner has been declared a foreigner post 25/3/1971. Para. Let notice be issued returnable by 6 weeks. 3. Union of India, G. Pegu, CGC for 1. Then G. Sharma, Standing Council Home for 2. 2, 4, and 6. 5 is P. Sharma. State Council, not 5, 3 is P. Sharma, District Commissioner, and Madam S. Kotoki is Ms. S. Kotoki for 5. Extra copies to be furnished within 2 working days. Para. 3. Roy Chaudhary, the Learned Council, praised for an interim order. Para. Considering the facts and circumstances, it is directed that till the next date fixed, no steps for deportation of the petitioner be taken.
Obligation. May I please, this is a contested matter, Your Lordship. Your Lordship will find at page 59 the impugned order. Herein, Your Lordship, the petitioner has deposited 11 exhibits along with 4 DWs. And those exhibits that were given in regards to the link,
Impugned opinion of which date?
2017.
What were you doing?
Lordship, I have given the explanation herein at
Okay, we'll issue notice at this stage. Leave the aspect of maintainably open.
the way I have explained in the para 15.
Okay, heard. 3 S. Ahmed, Learned Counsel for the petitioner, who has filed his petition under Article 226 of the Constitution of India, challenging an opinion dated 28/11/2017, passed by the Foreigners Tribunal Nagaon 7th, Lanka, in case number so-and-so, by which the petitioner has been declared a foreigner post 25/3/1971. Full stop. Issue notice returnable by 6 weeks. Union of India, GPEGU,
Yes, Lord.
CGC, then Home Department, G. Sharma, 2, 3, 5. 2, 3, and 5. Then P. Sharma by 4, and that's number 6. N. Kolita on behalf of AI Ali, Standing Council, Election Commission of India for response number 6. Extra copies. Okay. While the Learned Counsel for the petitioner prays for an interim order, the same is resisted by the Learned Counsel for the respondents, who have also raised a question on the maintainability of the writ petition on the ground of laches. Full stop para. Considering the above and by balancing the equities, it is directed that till the returnable date, no steps for deportation of the petitioner be taken.
Obligation.
The issue of maintainability is however kept open.
Obligation.
You're also late. Why?
Lord, we have explained, my lord, in paragraph 11 and 12, my lord.
19, we're in 2025, 6
Lord.
years out there after. Okay, same order, huh?
Lord.
His R. Ali, the impugned opinion is dated 27/12/2019. Vacation sab eke. Our FT number bodli jabo.
Yes,
Case number
54.
bodli jabo. issue notice of খালি কোনে accept কৰিব মই চাই লৈছো বাকিখিনি exact লাগে 1 to G Pegu then Mr. Sharma for 2 2 4 and 6 Sharma 3 by and Kolita on behalf of AI Ali for 3 and 5 by P Sharma State Council বাকিখিনি একে maintainability not to be reported maintainability question open take steps lordship public
My please, your lordship, opinion is at page number 92. Opinion is of dated 29/11/22.
22 what is your name
J.A. Sikdar.
you are not on record
No, lordship.
on behalf of whom
A.R. Sikdar.
on behalf of A.R. Sikdar you are J.A. Sikdar
J.A. Sikdar.
R. Sri J. Sikdar, learned counsel appearing on instruction of A.R. Sikdar.
Mhm.
Bakikine a case of notice of motion,
कुछ लिखो.
impugned opinion hold 29/11/2022, passed by so-and-so Gwalpara, Sailaba, in case number Sailaba. So they issue notice. Bakikine is Union of India, G. Pegu, number 1, State of Assam, Home Department, G. Sharma for 2.
Yes,
2, 4, 6. 2, 4, and 6. 3 is by P. Sharma. And 5, he'll take and call it on behalf of AI for Pakihine case, maintainability, that you put it. Not to report, but
Obliged.
question kept open.
May I please, your lordship, matter may pass on for the day, lordship.
Pass over for the day. You have waited whole day for making this prayer.
No, lordship, my senior is left.
What is so difficult in this case? It's an FT matter. We're going to issue notice. Any objection in issuing notice?
Lordship,
Hmm?
interim prayer is
Cannot
also.
get an interim, 16/11. 16/11, what do you say? Huh?
him on bail of
If he's not already.
reported.
But this is also not, on the first day bail is also not very palatable in these matters. Okay. What is your name?
Miss A. Begum,
Are you there on record?
lordship.
Heard Miss A. Begum, learned counsel for the petitioner, who by means so and so, huh? Like a back in Ekadiba. Impugned order hold. 16/11/2024 in FT case number so and so by FT 3, 3rd, Nagaon side of issue notice. Returnable 6 weeks. Who will accept? 1 G Pegu, then G Sharma for 2,
5,
2, 5, 6,
8,
8,
and 9.
and 9. Chief Election Commission of India, yes, Madam. Eskotoki for 3. State Election Commission, R Dubey 4. And 7, you will be taking P. Sharma. Extra copies, huh? The learned counsel prays for an interim order, which however is resisted by an interim order and has submitted that till date the petitioner is yet to be arrested. The aforesaid interim prayer has however been resisted by the learned counsel for the respondents. After considering, our prayer ideas, I reached 5,000 if it's not arrested. I had to deal.
Much obliged.
May I please, lordship? So impound order page number 37. Date of order 31/7/25.
You have termed the opinion to be absurd. Why?
Honorable Court,
Why is it absurd? What is the meaning of absurd?
linkage is there, but they did not accept the linkage.
Absurd means something, it's a very strong term, madam. Against a judicial order, do you would use employer expression absurd? Let us see the opinion.
37 page.
Absurd means calling white as black, more than perverse. Page 27,
37.
37. What is your name, madam?
MD Methi.
Heard Miss M.D. Methi learned counsel for the petitioner who has put to challengeable Eke order. Opinion dated. What is the date of the opinion?
31/7/25.
You have stated everything in the synopsis, but not the date of the opinion. Have you stated the date in the synopsis?
Oh, yes, my lord.
That is more important. 31,
31/7/2025.
25 passed by so and so in case so and so. That notice be issued returnable by 6 weeks. G. Pegu 1. Then Election Commission of India and Kalita on behalf of AI Ali 2. Then G. Sharma for 3,
3, 4, 6, and
3, 4, 5 also.
5. No, I am not preparing.
Member Furnace Tribunal.
No.
Who takes me?
Lordship, I think this should not be necessary.
No, since he's made a party. Okay, but take it, 3, 3 and 3, 4 and
3, 4.
and 6. 6 and 8 also.
Yes.
6, 8. Then Thakiba going to 5 or 7. And 7 is by 7. Hazarika will take.
Yes.
Hazarika by 7. At this stage, notice is not required to be issued to the respondent of 5. Extra copies. Which date? 31?
No.
25, okay. We'll give grant bail, okay? And say same, paid for interim and submitted the petition is yet to be arrested. Registered, then grant bail, okay.
All yours.
কোনটো আছিলে আলতাপ আতাপ এনেকে সেই দুটা দি দিব পাৰা আছে নেকি Mr. Borbhuya, your matters were there. F.U. Borbhuya, we fixed today. No, I live for এই যে আটা পারো কি বলতেছে 17 is there was some
Lordship, yes, Lordship. Perhaps notice was not served till date, Lordship. Earlier steps has been taken, Lordship. Lordship, only 1 week time may be allowed, Lordship. So concern SP Lordship, I shall take this step, Lordship. LCR has been received, Lordship.
what is the matter about
Lordship,
matters
Lordship, State SLD judgment and order dated Lordship 14/7/2016 passed by Furnace Tribunal, Borpeta, Lordship. FT1 Borpeta.
if you neglect like this how will the court help you? When can you come back? The Lozima Court, learned Lozima Court had also granted you time on 2 occasions
Yes, Lordship.
to give the information regarding the respondent number 1.
Yes, Lordship. What happened, Lordship? Our names also not shown in the.
Well,
Was
once
this
the
Lord-
state of Assam has been shown,
Yes,
whose
Lordship.
names are shown, that is
SDFT.
beside the point.
Yes, Lordship.
You cannot take up
Any
this
date,
kind of-
Lordship.
We grant you time till Wednesday next.
Yes,
Otherwise, we'll
Lordship.
close this.
Yes, Lordship.
Can't go. Seen the orders passed by the learned Lozima Court requiring the petitioners to furnish information regarding the address of the sole respondent. What's the para? Sri G. Sharma, the learned Standing Counsel, Home Department, prays for a little accommodation. Para, considering that this matter is pending since long, accommodation is granted.
To concern SP, Lordship.
No, you can get the information. Why should we direct the SP?
Yes, Lordship.
It's for you to give the information so that the steps may be taken. Accommodation is granted to the learned council, state council, to furnish the necessary information. Put the list on today's 14th. List on, we'll have it on 24th. 24th. One more than a week's time.
Lordship.
May I please your lordship? I'm appearing on behalf of K. Devi. She's not feeling well. She's having some personal difficulties. Kindly pass over the matter for the day.
There's nothing to be decided here. It's already been disposed of. This matter has already been disposed of, but the order of disposal was kept in abeyance for 30 days. No mat, no mati. No mat, no. It was order to put us up. Then order to
It order 9,
16/11/23.
16, 11, 23.
16. 16. 16.
16, 11, 23. Copy of the sender.
No, sir,
Then
it's-
I will take a copy.
There's nothing to be decided here. It's already been disposed of. It will copy it. Didi bolega second. সপ্তমা পঠাইছে না পঢ়িব পৰা নাই অজত 39 পেৰাগ্ৰাফ লিখি পেলাই থৈ আনিল 45 point.
So video. What's this?
এইটো চাওক না at this stage মানে অৰ্ডাৰটো আজি তাতে ডিক্টেট হৈ গ'ল এনেকুৱা টাইপ হ'ল at this stage so and so submit the still advise the country approach the honorable supreme court in the field shall be kept in 30 days
Below also. So.
ডকুমেণ্টে কৰিব লাগিব এইটো চহী হোৱা নাই নহয় after an order is not an order
Okay.
okay we'll have it on when Tuesday okay a request for adjournment has been made on behalf of Miss K Devi Learned Council on personal grounds full stop however considering that this matter is pending since the year 2017 the same is directed to be listed for admission hearing on Tuesday. Please give the date. Tuesday, no adjournment, 17 matter.
I think 17.
May I please, Lordship, this matter can be adjourned for today. My senior is outside.
Okay, same order. KDB that AR Singh huh? So Tuesday.
Obliged.
It was a big place of the
This is not Monday morning.
কি হব None appears for the petitioner on call, whereas the learned counsel for the respondents are present. Full stop. Para. In the interest of, the matter is pending since the year 2017. And this court has noticed that though the same was disposed of earlier, wide and order dated 11/6/2019, comma, the same was observed to be reviewed wide a subsequent order dated 25/1/2023. Full stop. Be that as it may, and in the interest of justice, a further chance is granted to the petitioner to make representation. Full stop. List. List on Wednesday next, the names of the counsel for the petitioner be properly reflected in the cause list. Review order to come to my query for that. Main order. Main order. ঠিক আছে discussion কম আছে কিন্তু discussion নোহোৱা নহয় second page to sir এরপর উপর into introducing the sense গোটেইখিনি আছে যেটা সব এটা রিভিউ করা যত বড় এখানে কোড করলে reading of the aforesaid for restricted order makes it discernible that the word further consideration কি ফরওয়ার্ড কনসেপ্ট কি রকম লাগে একটু কি কথা হবে রিভিউ নিয়ে আমার বহুত সার্কামস্টেন্স বলে দিয়ে আমি খুব রাউন্ড এটা মেনশন করে নাই রিভিউ
The sufficient cause.
এটা তো রেডি এটা তো অর্ডারও রাউন্ড অফ ভ্যালু না হয় তো petitioner for the whole order, legal sciences. They would not find any informative findings of the tribunal and wait themselves. They can put court as a review, let the ground of the court review. কি করেছে unnecessary complicated করবে এটা ওগুলোর নাম ওঠা নাই কজ লিস্টতে পিএন চৌধুরীর নাম আহা নাই নাম হয়েছে কোনটা বেলেগ আগর কেটা নাম হয়েছিল ইউটিউব থাকাটো অরিজিনাল রেটেড থাকাটো আজকের বলা দেখি বলা আহা নাই পিএন এর নাম নাই আকৌ এটা চান্স পাব রিভিউ করার কাৰণে নেক্সট দিন ডিসকাস করে কল করেছিল এইটোৰ এটা কপি কৰি এইটো ফাইলটো থৈ দিব লাগে দেই নহ'লে এইটো গমে নাপাম মই কিহৰ কাৰণে আহিছে আৰু এইটো পিন আপ কৰি থ'ব লাগে এইটো যদি আমি নাপাওঁ এইটো কিহৰ কাৰণে ডিছপ'জেল আছিলতো ৰিভিউৰ পাছত আকৌ লিষ্ট হৈছে কিন্তু এইটো পিন আপ কৰি থ'ব লাগিব ওপৰতে নহয় এইটো পিন আপ কৰিব লাগিব তাতেও দিব লাগে এইটো উঠাওক
April. As per the last order, Your Lordship, the second copy was mixed up with another file, Your Lordship.
Yes, that was in 6/1/2025.
Yes, my lord.
Now today, what is your difficulty? Today we do the matter.
Yes, if there is, the engaged counsel, Mr. P. Rahman is out of station today, Your Lordship. I am S. Islam. My name is not there, Your Lordship. I am on behalf of Mr. P. Rahman. Only one would say granted. If the case is rectified.
18 matter we cannot grant one.
Yes, my lord, I know.
We'll have it on Tuesday next. Tuesday. Tuesday. What is your name?
My name is S. Islam, Your Lordship.
Item number 19. No? S. Islam, Learned Counsel. Praise Learned Counsel appearing on behalf of whom?
P. Rahman.
P. Rahman. Praise for an adjournment. Full stop, considering that this matter is pending since the year 2018. While adjournment is granted, while a slight adjournment is granted, the same is directed, the case is directed to be listed for admission hearing on Tuesday next.
Masafik.
10:20.
After 18, it has not come.
Lordship,
After 2018, it has not listed.
yes, Lordship.
Oh my God. Here he is.
Once I have mentioned before the court, but
Okay. Yeah. Yes. What is your case?
Lordship, in this case, kindly to challenge the opinion dated 3/3/2018, Lordship. Annexure 2, page 20.
3/3/2018.
18, Lordship. Page 20. Very nice. দেখো যে উপরে দেখান এই আকর আকর এটা মনে হয়
Which page?
page 20
20.
20. After receiving summons from the tribunal, Lordship, she appeared and the petitioner filed her written
Okay.
statement as well as subsequently the case was heard. And she exhibited, Lordship, at page 22. Seven documents, Lordship.
Yes.
Here she exhibited certified copy of the voter list of 1966 or Ampara Nonke in the name of parents of the opposite party. Lord. And all other 70 voter list, subsequently 1985 voter list of the petitioners. In the meantime, Lordship, after 75, she got married. Her date of birth of 1956 born. In 1970, she got married with
Date of year,
56,
year of birth?
1956, Lordship.
Okay.
As per her written statement as well as her evidence, Lordship. She got married in 1970. Thereafter, she shifted to one Mamunpada village of village Mamunpada, PS Matia, district Gwalpara. Initially, she was in Bagbor area, Lordship. In 1985, her name has been enrolled in the voter list because up to 89, Lordship, the age of enrollment is in 21 years. It came up. 18 is come out after with effect.
Let us see her parents' voters list.
Lordship, in this case, they can mention here in the order itself that she has submitted all the voter list and other things, but the learned tribunal only, I mean, relevant portion I am reading that. Page 23. একদম বেয়া আছে। It is not so clear, Lordship, at that time.
Doesn't matter.
Mention here in but the name of the type করবো লাগছে। Monuddin Ahmed, wife of son of A. Hussein, aged what 40 years. Okay, this is recorded. If Lordship permit me, Tuesday.
Why, we could have,
I'm ready to do also, but
we are also ready.
I know, Lordship.
We cannot say, we cannot afford to say we are not ready. That luxury we do not have. We cannot seek for adjournment, can we?
Yes, yes, Lord, I'm not thinking because
Clear
it
justice
is,
case.
it is, I also want to go through the case, 2018 case matter.
You go through, no problem. We keep
Yes.
on reading. Let us see what are your exhibits.
Exhibit, she has exhibited all the documents regarding
see,
her
let's see.
parents,
Where, which page?
but subsequently, Lordship, after the order, she has filed an application under order that is 3A of 2 or 1964 orders. But that was not entered in.
That
That
was
is,
for, that was for what purpose?
For the purpose of some documents she has given to his counsel to file the before the learned tribunal, but that the counsel he did not submit all the documents. That is why she immediately after that on
Let
3
us see what documents you had given. Which page?
that page 26 annexure 3, Lordship.
No, no, let us see what are your documents before the tribunal.
Yes, Lord. Annexure 2, page 4.
Where you go? Question is judgment. Isn't
Page 30, 39. Certificate of Gambura. Showing the relationship with her father.
Three capital A. 64 only. Edu কি নাম? Oh, that application is under 3A2. What is 3A2, madam?
For review of the.
What is 3A2? What is the what is the provision? Where is the Act of 1964? Mr. Sharma, what is
Yes.
3A2?
It is in 3A2.
For expertise or not?
Not only expertise, Lordship. It is. It will look. To review of the opinion of
The proceeding may file an application to the Foreigners Tribunal within 30 days to review the decision of the Foreigners Tribunal claiming that he is not a foreigner, and Foreigners Tribunal may review its decision within 30 days of the.
You are reading which provision? Three,
A2.
3A2,
Yes,
Foreigners Tribunal order, Lordship.
order 64.
order of 1964.
Yes, Lordship.
Procedure for setting aside.
Immediately after
That is
within
3C.
Lordship 3A.
3 years.
Lordship English book है.
Is it 3A or 3C2?
3A2, Lordship. This is this book, Lordship.
Which book are you holding?
Foreigners law written by Dr. B. Ahmed, Lordship.
You have the amendment up till
Oh, yes, Lordship. This is. Here, appellant may appear either in person through a legal practitioner or a relation authorized by the appellant in writing, subject to the acceptance of such procedure for disposal of it.
3C2.
3C2.
There's a change, madam.
Yes.
It's not too nice. It took it here, amendment.
19.
99.
2019.
Order was passed on 18. Order was passed on 18.
So here 3C is mainly for ex parte order.
Yes.
Yes,
It is not an ex parte order.
Yes.
no, Lordship.
Then
But
how
in earlier,
only in an ex parte order,
yes, Lord,
you can invoke the powers in the 3C.
but it is in this book, Lordship. It
But
is
in
in
that book,
prior to 18.
prior to 18, but this, that book also, only the numbers have changed.
Yes.
What is the heading? Heading is procedure for setting aside ex parte order.
Yes, Lord, 3 procedure for setting aside
Ex parte
ex
order.
parte order.
Yes.
Subsequent to that, Lordship.
Yes.
Subsequent to that,
It is all concerning ex parte orders.
the proceeding may
The
file
procedure
an
to file
application.
These are all part of the ex parte order.
The proceeding may file an application for,
You cannot read to subsection 2, whether it's 3 or
Tribunal.
3C, doesn't matter. It has to be read with the heading of the section. Procedure for setting expert. It has to be expert, it's not an expert. And we are not deciding that. We are deciding the opinion.
yes,
Whether that
but
opinion is reviewed or not, that's a prerogative of the tribunal. We're now examining the correctness of the opinion.
opinion.
Yes. What are the documents, madam?
Here I have actually not an exclusion.
No, in the written statement or in the evidence, what did you annex?
Here's the next, but I have not annexed here.
No, you may not have annexed. What are the documents? Kindly let us know.
She has mentioned about
Where is your evidence?
Lordship.
Mr. Sharma, the evidence?
Yes,
Statement is a page.
I have got the written statement at page 15.
Yes, sir.
Page 15 is the written statement.
Yes, evidence was known.
Yeah,
I think, oh, yes.
Huh?
Page 25, Lordship. Oh, no, no.
No, no.
25, Lordship.
Wait, like,
Not an explosion.
the report was,
Not an explosion.
but in the order sheet, it is mentioned, Lordship. How long? Briefly. In the judgment itself, Lordship, they have mentioned, Lordship.
Yes,
It is mentioned
Yes.
about,
yes, what are the documents?
that is, Exhibit A is the certified copy of the voter list of 1966 of the parents of village Rampara Nonke in the name of parents of the opposite party. Exhibit B is the voter list of 1970 of village Rampara Nonke in the name of parents of the opposite party. Exhibit C is the voter list of 1985 of the village Mamunpara in the name of the opposite party and her husband. Exhibit D is the certified copy of the voter list of 1997 of village Mamunpara of the name of the opposite party and her husband. Exhibit DE, certified copy of the voter list of 2005 of village Mamunpara in the name of opposite party and her husband. Exhibit F is the school certificate of opposite party. It is issued on 11/11 to 1999, 93, Lordship. G is the copy of the damage report of the school issued by the charge headmaster of the Rampara NC school. But these two exhibit she could not prove due to the he has submitted all these documents, but the council told her not.
66.
The learned court below, Lordship, only mentioned that it is not trustworthy. 35.
Abdul Aziz. Ahmed Kulson. Ahmed Kulson Yasa.
Right. What is date of birth? 56.
Mamunpara में किला कुछ रामपारा कुछ नहीं है रामपारा
Bagbor.
একদম ক্লিয়ার নেই জানে আগরটা ফাইল হচ্ছে যে একদম ক্লিয়ার নেই মোর নিচেটা
Next one, 85, the 97 taken.
Fulson. Ahmed Fulson. Fulson.
Given birth,
39 or 26.
what's that of 85?
85 to be absorbed. Moinuddin Ali.
That's a term. Now, I have a term. Also 97. 97.
Ninety-seven, 42 was a high second, page 42,
One you do not.
49.
Of 2005.
This is added, high second, 47.
See, madam, the voter list
Yes, Lordship.
of a period which is not relevant will not make any difference. You say that you were born in the year 1956.
Yes, Lordship.
You have to show certain links which are acceptable link with your parent, with your father.
Yes, Lordship.
You have given the voter list of 1966 and 1970 of your parents.
Parents.
Thereafter,
Thereafter, she got married with that person,
now you got married in the year 1970.
70. And she shifted to Mamunpara, Lordship.
Okay, from 70 to 85, what happened?
70, because that time I have mentioned in my petition also, Lordship. At that time, her age was about 14, 15, 16 years, Lordship. That time, and she cannot.
No, 70 to 85.
85, because 70 to 85, 85 she attained the age of 30. Because in 1989, the 20 years, the enrollment of any person's name has been come.
No, that we have understood. But from 85 and 70 to 85 is 15 years.
Yes, but at that time she has not attained that age.
You have attained 21 years. In which year? Which age?
30 years.
No,
85.
no. At 21, you can vote.
77.
What has happened thereafter? It's from 70.
Thereafter, the next 85 years, her name has been enrolled. Lord.
And prior to that, 85, you are aged about 30 years.
30 years.
So prior to that, 9 years. What
Not
was
9 years, Lordship. 77, she attained the age of 21 years.
Where is that list?
Lordship.
Where is that list?
List.
Where is that voters list? Which contains your name? Suddenly your name will not come at the age of 30. Your age will be
She had, after got married, she came to that Mamunpara, Lordship.
Yes.
That time she has not attained the age of 30.
We have understood, madam. The
yes.
year which you have, when you have entered 21 years, your name will be entered into the
In a
voter list.
rural area, Lordship, more people can come immediately after 80 because
9 years.
9
21
years.
to 30 years.
No, 18 years.
9 years.
In 89, she attained the age of 20 years. Oh, sorry, 79. 21 years.
And your name has entered for the first time in the year?
Year 85, Lordship.
Unexplained. And how do you put a link with your parents? There may be some other documents.
That is why, Lordship, that affidavit was filed. A review petition was filed before the learned court below.
There is no order of rejection or entertaining. You
No,
cannot be
Lordship.
by that.
I specifically mentioned in my petition about that the learned court below refused to entertain the petition.
You have to have.
That is why we have annexed this petition also before this honorable court.
Now that is not a subject matter of challenge before us. We,
I have annexed, Lordship.
you have annexed.
I have annexed along with the copy of that Gaura certificate of that his father, linkage with the father of the petitioner, Lordship.
We have to adopt, go by the standard norms which were,
That is in annexure, page 40, Roman Potro.
we can at best examine the opinion of 3/3/2018, which we are doing. The other part is not even a subject matter of challenge. There is no cause of action. There has
But,
to be a rejection.
But,
It has to be
but subsequently, I have filed this before this honorable court, annexing all the, because I have come only on against a review petition. I mean, in my prayer also, I have mentioned about the review petition, Lordship.
Where you have mentioned? about the review petition?
My prayer also, Lordship, that is page
Page 12.
12,
Yes.
Lordship.
Where is the that portion of review in your prayer?
The respondent to show causes to whether it in the nature of services shall not be issued by setting aside the quashing the impugned order of opinion dated so and so by the learned foreigners tribunal, declaring petitioner is a suspected foreigners, annexure 2, and also show cause as to whether it in the nature of amendment should not be issued, directing the respondent to allow the petitioner to produce the documents which would not produce during the proceeding of FT case number so and so, and to allow the petitioner to prove her case by adducing evidence in accordance with law.
So unless the earlier order is set aside, you cannot proceed parallelly. First, you say that you have filed an application under clause 3A2. Then you also challenge that order opinion in the.
Yes, without modifying this order, Lordship.
You have not prayed for anything that you give a direction to the tribunal to decide that petition. That is not your prayer.
This is my prayer.
That is not your prayer. You have allowed that the respondents should be give you a chance to allow. Who is respondents? How will the state give you a chance? There's an order against you, which is the subject matter of challenge.
I have specifically mentioned about that, Lordship. That
Which respondent will allow? Is the tribunal a respondent before us?
but government is here.
Government is not the adjudicating authority. It's a tribunal.
We cannot make the tribunal as a party in this case, Lordship.
So how can you give a direction to the tribunal?
Because a review petition filed before the tribunal.
You press your review petition, then you come back.
No, press I have filed, but the court the
So where is your prayer? Making a tribunal a party, that kindly tribunal give a direction to the tribunal to dispose of a review petition. That is not even your prayer. There has to be a specific prayer.
ample power in extraordinary jurisdiction
No,
to.
there has to be some indication. The tribunal itself, whom do we direct? Can we direct a person who is not even a party to decide a review petition?
In every case, Lordship, in even other cases also, CPC or other, whether we make party to.
Madam, these are distinct prayers. We understand in certiorari jurisdiction, you may not make the tribunal a party, but when you are seeking a direction to the party, whom do we
We
direct?
cannot make a party to the court, Lordship, any court.
Huh?
Any court, we cannot make a party, even in revenue board matter also. The court
Don't make a party, this choice is yours, we cannot give a direction. This is not an appellate jurisdiction, madam, please try to understand.
It is an
This is neither revisional
it is under
jurisdiction,
extraordinary
this is not
jurisdiction.
appellate jurisdiction.
The
In a
foreigners
226 petition, what is the bar in making the adjudicating authority a party?
Foreigners Tribunal, a quasi-judicial body, and this honorable court also can direct the any party to.
No, we are not taking such hyperactive step. Unless you make a party, unless there is a prayer to direct the tribunal to consider your application under 3A2, We cannot, we are considering your application for setting aside the impugned judgment of 2/5/2018. If you can make out,
She has submitted all the documents regarding the certified copy of the fathers. But there is not a linkage. That is why we have submitted before this honorable. It is also in before this honorable court in which I have annexed in the review petition.
where page? Page
Page 4. Page 40.
40,
Yes, 39 and 40. It is translated copy, Lordship.
39.
Yes, Lordship. And main copy is 40.
Date of this?
That is subsequent to the 2015, Lordship.
Twenty-four, 6/15, yes.
The petitioner handed over all the papers to his counsel, but he did not produce before the learned court below tribunal, Lordship.
What steps have you taken against the council?
Lordship, every person, it is not possible. I have seen in my bar council, Lordship, there is so many cases
No,
pending.
you are fighting against your right. Your citizenship is in doubt. And you are sitting here, it's not possible to
Lordship,
take. Who is the council?
I am also one of the member of the bar council, Lordship also.
Have you taken the name of the council? Where is the name of the council?
Everybody is not.
Where is the name of the council?
Everybody, it is not a position to come and fight for before the.
What is the name of the council? At least the name.
He has filed his.
If council has neglected to fight your case, and you have not, and you think that you cannot approach the
Due
bar
to ignorance of law, so many cases is pending before this honorable court. And for that,
have you named the council?
I have not named.
Have you filed an application against the council in the bar council? No.
No. So many cases dismissed. Last occasion, I also sat in the bar council's meeting. I have seen how to handle.
Where is the averment that the council did not take steps?
Yes, sir. I mean, did not take steps. Para 13.
1-3. Yes. Please read.
And that the petitioner respectfully submits that it is the settled law that no order of the court should prejudice either of the parties. The petitioner begs to submit that the aforesaid anomalies has happened because of the fact that the petitioner was wrongly advised by the council that the above documents were not relevant, as all the documents produced before the honorable tribunal were sufficient to prove her nationality. Therefore, the same could not be drawn to the attention of this honorable court at the time of passing of the order. The review petition of the petitioner solely on removal of error apparent on the face of the record, but the learned tribunal refused to accept the application under section 3A2 of the Foreigners Tribunal Order 96 arbitrarily, which reflects predetermined mind of the on the part of learned tribunal so and so. And in the very much. গোটেই বস্তুবিলাক দিয়াই নাই।
কৰে কিন্তু petition বোৰ
refuse to accept খালি সেইটো আপুনি justify ল'ব পাৰে expert order নহয় কি পাৱাৰত accept কৰিব ইমান ফাৰ্ম ক্লাছ অফিচাৰ হৈ গ'ল মানে বোলে you come to go to the high court
উঠিব দিছে।
okay yes so you say that 66 is the voter list of your parents
Yes, Lordship. And 17
Asanullah Bepari
Bepari,
and
yes, Lordship.
Onyx Pulan your Nessa your mother
Yes, Lordship.
70 name of the parents then 85 your name comes
Yes, Lordship.
by the time you are aged about 30 years then rest are subsequent to 85
Yes, Lordship.
and you have also said that you have filed an application under 3A2 which was refused to be accepted
Yes.
that is your case
Yeah, I have submitted some documents that was not produced before the learned tribunal, showing linkage of the petitioner with her parents' Lordship.
Which,
And moreover, this
which document?
that annexure, that is page 39 and 40, Lordship. 40, 41. Two documents, Lordship. Gaura certificate. And page 42. 43, Lordship. And the case was referred by the electoral registration officer to the SP, and SP through his SI mechanically filed this, forwarded the matter before the tribunal, Lordship. Whereas the electoral registration officer has no authority. It is in the record itself, Lordship, first page of the record.
What about the disclaimer part at page 42?
Lordship.
What about the disclaimer part in page 42? Last part.
Only establishing linkage with the parents.
ভালো হ'ব নোৱাৰে এইখন হ'ল দিছে তো আপোনাৰ গাঁওবুঢ়াই এইটো চাপৰি এই বৰপেটা ডিষ্ট্ৰিক্টৰ গাঁওবুঢ়াই ইয়াতে লিখিছে মেনশ্যন এপইণ্টমেণ্ট এণ্ড ডিপাৰ্টমেণ্ট দিছে তো চাপৰি মানে বৰপেটা কিন্তু got married in Rivalpur district আৰু marriage হ'ল কেতিয়া 1970
বাপেক হলে হেৰি
70
বাপেক ইণ্ডিয়ান হলে হৈ গ'ল মাক নহলেও হ'ব।
70 yeah it's a permanent
বাচ্চা হলো
2015 apparently
ফৰেনাৰ্ছ নহয়
next one sir
বাচ্চাবিলাকতো ফৰেনাৰ্ছ নহয়
বৰপেটা district
সেইটোৱে মাকক ধৰিছে তেতিয়া গৰু ছাগলী দামুৰি চব লৈ যাব লাগে নহয়
ইয়াতো ফাৰ্ষ্ট এখনতো নাও
নহয়।
ফেমাৰ আছে এইটো
মোৰ কথাটো এজানো কৰি বাচ্চাবিলাকক কিয় এৰি দিছে
এটাতো ৰাখি দিয়া নাই এই দুখনে আদৰি
চবতে ইয়াৰে হৈ গৈছে একো নাজানে এইবিলাক কি শিক্ষা হওক বাপেকৰ
এই বস্তু
প্ৰপাৰ্টিও আছে এইবিলাক আনিবও পৰা নাই
3 years fight কৰিছিল
নহ'লে মই নকৰোঁৱেই আজিলৈকে যিমান কেইটা হৈছে মোৰ চব ভাল হৈছে
for the election whether sir
তাকে তাকে নকৰোঁ
Yes, Mr. Anything else, madam?
This is the in the first page of the record I have seen, Lordship, that is sent by the electoral registration officer. He is not empowered with the
Who is not empowered?
electoral registration officer. He has forwarded the matter before the SP, and SP thereafter mechanically submitted before the learned tribunal. Initially, it is an under the
ERO does not have the jurisdiction.
yes, Lordship, because I have one case earlier, and this is the judgment of this.
Who has the
Honorable-
jurisdiction?
Yeah. Electoral registration.
Who has
officer.
the jurisdiction?
Well, SP only.
SP.
Yes.
SP has given.
Mechanically forwarded the matter as on the basis of the report of the electoral registration officer, Lordship. It is
The SP will act on certain materials. Now, if there was no recommended reference by the SP, matter would have been different. But SP border has referred the matter.
only
referred to
mechanical matter has been referred subsequently, Lordship. But on the basis of the report of the electoral registration.
That is
officer.
what we are trying to
Yes, Lordship, this is the
say.
judgment
The
of this
SP
honorable.
would depend upon certain materials.
No.
Now,
Even
when you are saying that SP has mechanically endorsed
yes,
the, on what basis? What is your basis of the submission?
there is one form number 1 and 2 submitted by the
SP.
not SP. Yes, sir. Subsequently, it is by SP. Yeah. I have seen there. Only after endorsement by SI, then he has sent the matter to. That is why, Lordship, this is the judgment of this honorable court.
What is it? What does it say?
Earlier, it is under IMDT Act.
Paragraph?
এই কোনটো দিছো নি? কোনটো? এইটো নহয়। এইটো নহয়। কি কৰিছো? Automatic queen or something. But dealing with
ৰেফাৰেন্সটো আছে নেকি আপোনাৰ?
yeah, I guess I can teach her a teacher more to release. Itu kung kaya kaso kaya tiap mo siya bili. দিলো নাই কি কৰিলো পটকে দি দিলো ভুলে দিলো নে কি দিলো নাচালো দুটাটো দিবই লাগিব মুৰ্গে পিছে আৰু আজি তাতো বেয়া থকাত মই একদম একো বুলিবও নোৱাৰো চিন্তাটো কৰি আনিছিলো মই
Electoral registration officer.
আছে নেকি ঠিকে কৈছে বিজনী মোৰ তিনিটাও যাব পাৰে
আপোনাৰ electoral registration officer পঠিয়াইছিল।
এইটোহে ৰহিম এইটোৱে মেনা মেনা বেগম নেকি
বুলি ক'লে তুমি তো মেকানিকেল
ইয়াৰো এনকুৱাৰী হৈছিল ইয়াৰো এনকুৱাৰী কৰা নাই নেকি ইয়াত পুলিচ এনকুৱাৰী হৈছে চাওঁ এনকুৱাৰীটো
এইটো বিয়াৰে ৰেফাৰেঞ্চ কৰিছে তাতো হেৰিত আছে এইটোত আছে ৰেকৰ্ডটোত আছে ৰেকৰ্ডটো চাই পেলাইহে মই কৈছো প্ৰথম পেৰাগ্ৰাফতে লিখিছো বেচিং অন দ্য ৰিপৰ্ট অফ পিয়াৰ এনে সিহঁতে চিল আৰু ষ্টাম্প মাৰি পেলাই পঠাই দিছে বুজিছে চিল আৰু ষ্টাম্প মাৰি পঠাইছে তাতে আছে ৰেকৰ্ডত আছে
In that case, the reference was made directly by the electoral registration officer.
Yes,
Who was not empowered.
Yes.
Here we have found endorsement by the SP. And he made an
Only
inquiry.
endorsement, Lordship, it is mechanical.
No, he had asked for a report from this.
And in the Lordship, in judgment also, no reference about which period she has entered in Assam. No mention in the judgment. Whether it is pre 71 or post 71 Lordship.
Two, 4, 5 of 2019.
আচ্ছা এটা করতে লাগবে সত্তর বছর মানুষজনে যাবো 73 years
আপোনাৰ ঘৰত ৰাখি থওক
হা
আপোনাৰ ঘৰত ৰাখি থওক
বাংলাদেশ
আপোনাৰ ঘৰত
মোৰ ঘৰত মোক কোনে ৰাখিব মোকে ৰাখিবলগীয়া হৈছে এতিয়া Only opinion was made, Lordship, she is a suspected foreigners.
Okay. Yes, Mr. Sharma?
Yes, Your Lordship. Lordship, my humble submission is that Lordship, there is no infirmity in the opinion passed by the learned tribunal. And Lordship, proceeding has exhibited 1966 and 1970 voter list. And after that, Lordship, suddenly 1985 voter list has been annexed, Lordship exhibited along with her husband, Lordship. And Lordship, WS is totally fake, Lordship. Written statement is totally fake, Lordship. What happened to his parents after 1970? That was not mentioned, Lordship. And Lordship, apparently, my lord, there is no link with his projected father Asan Ali Bepari, whose name reflected in the voter list of 1966, Lordship. And proceeding totally failed to discharge her burden under section 9 of the Foreigners Act, Lordship. And Lordship, regarding what my senior colleague has claimed that, Lordship, regarding ERO's inquiry, Lordship. ERO's inquiry, Lordship, recently decided, Lordship, in a case, Lordship, WPC 245 of 2019. And earlier decision passed by this honorable court in respect of ERO's inquiry, Lordship, which was held in case of Sayamuddin, Lordship, that was upheld by this honorable court, and Amina Khatun case also distinguished in this case, Lordship. Here, Lordship, para 17 is relevant, Lordship. Here in para 17, Sayamuddin's case has been
17 of?
17 of WBC 245 of 2019. Sukurjan Nessa.
You have to give the,
Lordship.
how do you know para 17 without giving us a copy?
Lordship. 17, Lordship.
What is the name? WPC?
245 of 2019.
No, 24519. Name? Sukurjan.
SHUKURJAN
SHUKURJAN.
NESSA. Lordship, please. And only one copy.
26, gimana?
246.
Para 17.
245 of 2019. Para 17, then Lordship, para 22.
The date of the judgment? Oh, the government. 28 to 25. 28 to 25.
Date of order 28 to 2025.
Para 17. Yes, what has been stated?
Lordship. Para 17, Lordship.
Yes, please.
17, 22, Lordship. Amina Khatun was distinguished, Lordship, in this case. In para 22, Lordship.
Is it?
In para 20, Lordship.
Una minute.
22.
Para 20, Lordship. However, the case of Amina Khatun Supra, which was decided on 28/4/2022, in the reference was made by the Superintendent of Police Border based on LVO by the ERO. But when the said retribution was being heard and decided by a coordinate bench, it appears that previous decision of the learned single judge of this court, in the case of Sayamuddin versus Union of India and others reported in
2019 for GLT 456 as affirmed by the division bench of this court in Samuddin versus Union of Indian and others, Writ Appeal 170 of 2019 decided on 29/7/2019 were not brought to the notice of this court. Therefore, under such circumstances, the court is of considered opinion that under the well-settled principles of stare decisis, the decision of the case of Amina Khatun Supra would be per encuriam. Accordingly, the decision rendered in the case of Amina Khatun will also not be of any help to the petitioner.
Amina Khatun to কোন সনদ?
22 মানৰ হ'ব। আপুনি দিলে এইমাত্ৰ।
No, এইটো আমিনা তো বেলেগ। এইটো কোনটো আমিনা? আমিনা 3-4টা আছে। 4টা মান আমিনা আছে। Move to division when to matter.
Mr. Goswami, which matter you are waiting for?
Wait, Lordship directed to produce the report, my lord. If your lordship is kind enough to.
Which matter?
My lord.
Which
Yes.
matter?
DPS. 22.
Today will you have time?
No, today I think there will be no time, but the lordship directed to produce the.
It's a preventive detention.
Yes. Under 88.
Records are there,
Yes. Lordship may fix another date, my lord.
but we'll have it early.
My lord.
Next Monday or Wednesday. Tuesday we have fixed many matters. Wednesday.
Wednesday given right.
Who's on the other? You are on the other side. Wednesday.
Monday.
Monday will not come. Monday there are matters. Tuesday we cannot fix. We have fixed many matters. Wednesday we can have.
19.
19. Ma, can it be on 21st, my lord? 21st.
Already late.
We can, subject to your colleagues says 21st we can.
Otherwise,
Or have it on the earlier day, 28th. 28th would be better. 21st will be last day.
I have a fixed matter, all right, ma'am.
On Thursday. One day earlier,
Next
Thursday.
Next Thursday, you are right.
20 please.
Yes. 20th, I have a matter.
We'll accommodate you
All right.
because he has some urgency.
Yes.
Okay.
Let's.
201.
2020, paucity of time.
Madam, may I request one thing, madam? They have brought that confirmation order, my lord, which I have not yet received, neither detention received nor I, my lord. So, one copy may be provided, my lord.
We'll see first.
Yes. That
If
time-
we think that it was your submission is indeed correct, then we may allow.
Yes.
Paucity of time will not permit the matter to be taken up today, full stop. As urgency has been expressed by the learned counsel for the petitioner. The same be listed for consideration on 20th of November, 2025.
Obliged.
Others may not be possible today after this matter. Mr. Day is very happy to go home.
25.
Mr. Borbia, we had called your matter, you are not there, 2 matters of yours we had listed today, especially.
I was another phone.
You should have,
On Monday,
we'll have to see Monday, this bench may not be there. We had heard this matter, we had given preference to your matter. We'll have to another date, okay? This will be the last matter. After this, we'll have another date. Yes.
Yes, Lordship.
So Amina Khatun has been held to be in par incuriam
Yes, Lordship.
because the earlier coordinate bench of Sian was
Did
not.
Samuddin's case was not considered, Lordship. Yes. Lordship, and
No, but in this case, otherwise, we may disclose to you, you're also entitled to see the records. After the report by the officer, the electoral registration officer, the SP had done an inquiry. SP had called for an independent report through an inquiry by the SI.
Lord.
Only thereafter it was referred. So it's not a case that SP has not looked into the matter.
Lordship.
Of course, an argument has been advanced that the SP had acted mechanically. He had not applied his own mind, independent mind. That is the argument. But that argument has to be examined from what is in the records.
Yes, if there is ERO's inquiry, Lordship, then concerned SP has not authorized to done the inquiry, Lordship, at that time, at the time of intensive revision, Lordship. So, Lord.
No, this started during the IMDT period.
Yes, Lordship. Yes, Lordship.
This particular case.
Yes, Lordship. Lordship.
Submit your lordship. In this case, if a reference is made forwarded by the LVO, by the ERO on the basis of an LVO report, lordship, thereafter, as per the judgment of the Samuddin, lordship, which has been upheld by the division bench, it has been specifically stated, if I may read the relevant paragraph, lordship, it has been stated in paragraph 22 of the said judgment, in so far electoral registration officer is concerned, the exercise undertaken by him while marking a person as the voter in the electoral roll is a quasi-judicial exercise. If he holds the view after examining the inquiry report of the local verification officer that the concerned person is not a citizen of India, he is required to forward the case of that person to the competent authority, that is Superintendent of Police. If it is so forwarded by the electoral registration officer, the jurisdictional superintendent of police has to make a reference to the competent foreigners tribunal under Order 2.1 of the Foreigners Tribunal Order 1964 based on the report received from the electoral registration officer. Question of making further inquiry by the superintendent of police in such a case would not arise because inquiry has already been made by the ERO by exercising quasi-judicial powers, and the superintendent of police cannot sit over such decision of the ERO. He has to forward the same by making the reference to competent foreigners tribunal for
Mr. Ali,
checking.
the entire objective,
Lordship.
see, we are also aware that there is a forum
No.
to examine such decisions of
No.
tribunal whereby a suspect is declared to be an Indian citizen.
Lordship.
For those cases, there is a forum
Forum, Lordship.
to make an advice whether this case should be filed, should be challenged in a high court or not. See, we are mainly we are examining matters where a proceeding is before us. But the entire objective of the act is to declare the suspected foreigners as foreigners and expel them.
Lordship.
That is the these are all in sync with the act. That if there is a report
Lordship.
of the ERO
Lordship.
to make a
Reference
reference, then SPO cannot say, no, I'm going to make another inquiry.
Lordship.
But here in our case, we have seen that SP's inquiry is also in
Yes,
sync
very
with the
separate
report of the ERO.
Lordship.
There is no there is no dispute of the opinion.
That's it, that's it.
These are all in the sync of the act, that the objective is to, once somebody has come to a conclusion of there being some genuine reason of suspecting, then the matter should be referred.
Lordship.
So that is the.
In fact, in this case, Superintendent of Police has so utmost caution, Lordship.
Yes.
As independent inquiry has been made
In
from
fact,
his end
this
itself.
this will give us additional safeguard
Lordship.
to the the proceeding, which of course is not necessary.
Not necessary. That's what I'm not my submission is. Even if
If
you
the
are not
SP
required.
see the entire language which you have read, that is the in line with the objective, that SP cannot delay the matter in referring.
That
He
is
cannot say that, no, I'm going to make another inquiry. Once an inquiry has been made, you're furnished with the report, there is no requirement for you to make another inquiry.
That's it.
And otherwise, Lordship, there is nothing is there, Lordship, to link the proceeding with our projected parents, Lordship. And
Now, will this provision which Madam is harping, whether it is 3A2 or 3C2, will such an application lie in a contested proceeding?
yes, Lordship, actually, that part is in respect of ex parte order, Lordship.
Exactly, that is what we are trying to
Yes, Lordship.
try to get an
Whole
input from.
provision is for in respect of ex parte order. And regarding revision review, Lordship, there is no specific order has been found in the Foreigners Tribunal Order 1964, Lordship.
See, what
And
we understand,
even
review is a creature of a statute.
yes, Lordship.
Review is not an inherent power.
Yes, Lordship.
Unlike 226 powers, which are plenary in nature,
Mm.
all others are statutory bodies.
Mm.
Bodies which have been incorporated, constituted by a statute. Unless that statute gives a power of review,
Yes, Lord.
review powers automatically cannot be invoked,
Yes, Lordship.
which is not in the case of 226 powers.
Yes,
It's
Lord.
different, judicial review.
Yes.
Now, Here, there is a reference to a review, but it is confined to all ex parte orders.
Yes,
Whether
Lord,
it's
yes.
3 or maybe after the amendment 3C, we
Yes,
are not
Lord.
on that.
Three.
So once opinion is rendered,
Mm.
the foreigners tribunal will become functus officio.
Yes, Lord, sir.
It will not, cannot just without any direction of the High Court, it cannot just take up the matter again for rehearing.
Yes, Lord, sir.
Yes, if it falls under 3 or 3C, that is an ex parte order,
Mm,
you file
yes.
for an application to set it aside, then file for an application for review, it can be done.
Yes, Lord.
But this particular subsection comes under the heading of some ex parte orders. That is what we are trying to get some assistance from you. You read the section.
Yes, Lord. Report page number 2. Yes, Lord. See, procedure for setting aside ex parte order, where the foreigners tribunal has passed an ex parte order for non-appearance of the proceeding, and he or she has sufficient cause for not appearing before the foreigners tribunal, it may, on the application of the proceeding, if filed within 30 days of the said order, set aside each ex parte order and decide the case accordingly. The proceeding may file proceeding may file an application to the foreigners tribunal within 30 days to review the decision of the foreigners tribunal, claiming that he is not a foreigner, and foreigners tribunal may review its decision within 30 days on receipt of such application and decide the case on merits. But in this case, Lordship, application was not made within 30 days, Lordship.
No, we are not on that. We are not on 30 days or 60 days.
30 days we have filed.
We are not on 30 days or 60 days.
Yes.
We are whether an application for review can be made in a contested matter.
Lordship.
Whether this subsection 2 can be read independently or whether it should be read as part of the heading of 3A or 3C, whatever you say. Our new book is 3C.
3C. And section order 3C, Lordship, suborder 3, subject to the provisions of this order. The
See,
foreign-
Mr. Sharma,
Huh.
what we are thinking. First, we have to read the entire section.
Yes.
What is the section? 3C or 3A, whatever. Madam, we also want your assistance. Kindly have 3 or 3C. Have a seat, have a seat. Just listen to us. Procedure for setting aside ex parte order. See, there are certain orders. Ex parte order does not mean that the case has been decided.
Yes, Lordship.
There is an order that will proceed ex parte. That is an order of ex parte. So what is the procedure for setting aside ex parte order? Where the foreigners tribunal has passed an ex parte order for non-appearance of the proceeding, and he or she has sufficient cause for not appearing before the foreigners tribunal, it may, on the application of the proceeding, if filed within 30 days of the set aside the ex parte order and decide the case accordingly.
Yes,
See,
Lordship.
there may be an order, proceed ex parte. So this is one is in context of such an order. You set aside that order to proceed ex parte and you proceed in accordance with law.
Lordship.
Second is a situation where an order on merits is already been passed.
Yes, Lordship.
For not merits, disposal already been passed. Then the proceeding can file for review.
Yes, Lordship.
Otherwise, there was no purpose of having another section for
Section
review.
4.2. Yes, Lordship.
If it is in the beginning initiation that proceed ex parte, you file an application, get it vacated, start afresh. If second situation is the matter has been disposed of, then you file an application for review in an order of ex parte, and that has to be done within 30 days. Of course, that period can extend if you can make out grounds, like the provisions in the CPC.
Yes,
That
Lord.
is what appears from this provision.
Yes, Lord.
First part proceed ex parte next to already হয়ে গেল
শুনক,
এটা হচ্ছে বগৰী।
ধুনীয়া কেছ হৈছে, মই খবৰ ধুনীয়াৰ ফৰেইনাৰ্ছ ট্ৰাইব্যুনেলৰ মানুহকেইটা সুধিছো, এইটোতো ওপৰতে হৈছে, ইয়াৰ পৰাও ৰেফাৰ কৰিছে, বুজিছে, হাইকোৰ্টেও এতিয়া মোৰ আৰু তাত শক্তি নাই। আৰু এইটো যে কৈছে এইটো চব টাইম
Petition হয় একো order দিয়া নাই নেকি?
নাই নললে এই মোৰ লগতেই আছে
Are there any case precedents on this review power? I think there are.
Yes, my,
There are some-
what my lord, your lordship is querying, my lord. This is in numbers of cases, my lord. Of course, this honorable court has also allowed review in
Yes.
such cases, my lord, where there is no expertise order, even if it is not an expertise order. There is-
Even an interpreter order.
Yes, yes. Some instances are there, man.
No, this
And probably this.
No,
my-
Mr. Pang, there will be still a thin line of difference. See, our exercise of power under 226 is a plenary jurisdiction.
Yes, my lord.
So for the interest of justice, we may direct something to be done.
Yes.
But whether the statute allows a review to be entertained by a foreigners tribunal, that is the question. Whether that has been answered in the meantime.
My lord, my first reading of this enter provision is that it can only be exercised.
Confined
when
to
it
an
is
expert
expert
order.
order.
Expert order.
That is the first impression on
Yes,
of this,
yes.
my lord,
Second.
particular order. Now, this order was brought, my lord, probably this was not there. My lord, substituted in para 3 and 3A, newly inserted in
2019.
2013, my lord. With effect from 2013. The earlier, your lordship will get it in the earlier book.
One.
Para 3 was substituted by number so and so, which was earlier substituted in
তাতে
1965.
তাতে সিহঁতে এপ্লিকেবল এৰিয়ে চাক মোৰ কৰি দিছে
No, this was not 13, this is 19.
আছিলে
Yes.
13 is the last part. 4 has been added.
সেকেন্ড
Powers of foreigners tribunal.
Yes, this was on 10/12/2014, 13,
13. That last 4 is,
last 4.
this is of 19.
Substitute para 3
3C.
and para 3A.
No, 3C is a part of it. 3C.
Para 3 was substituted by number so and so. So, my lord, this is also from, as per this book, substituted para 3. Earlier, it was only para 3 and para 3A. Newly inserted 5 notification dated GSR 770E dated 10 December 2013 with effect from 10/12/2013. Para 3 was substituted by GR number so and so.
No, I think that is an old book.
Yes,
Here,
this is
para 3A and 3B, which were inserted in 2018,
Nine-
were renumbered earlier as paragraph 3A and 3C.
yes, my lord. That is in 2019 when this NRC situation came, my lord, and for that this order was amended.
So, Mr. Payang, if we read again, whether it's 3 or 3C, we are on the contents,
yes,
okay?
yes, yes.
Procedure for setting aside ex parte order.
Order.
So this is the heading, only
Yes.
for ex parte orders.
Yes, this is only for expert
Yes,
order.
yes. Number 1, where
Order
the
for
foreigners
exception
tribunal has
of
passed an
ex
ex
parte
parte order for non-appearance.
Non-appearance.
See, the proceeding has not appeared, proceed ex parte.
Yes, madam.
Now, proceeding has come to know, he can apply to set aside that order to proceed ex
Yes.
parte. That is 1.
Yes,
2 is a situation where the opinion has already been rendered ex parte. Then he can file for review.
the proceeding may file an application to the foreigner student within 30 days to review the decision of the foreigner claiming he is not a foreigner. Yes, my lord, this cannot be independent of my lord
1.
1.
It is a case situation where the opinion has already been rendered and only to save a situation where the tribunal does not become functus officio
Yes,
and proceedee who has been proceeded ex parte, he can come for review of the opinion.
that is my limited understanding
That,
also, madam.
that should be, it cannot be extended
Extended
to all
to
cases,
all cases.
contested cases.
But in some cases, my lord, this is extended, that's why.
Can you
But
give
my
some
limited
decision?
understanding is also that much.
Now, can you give some decision?
Yes, I can provide, madam, there are some. I have to check it out.
চালে ভালো হ'ব নেকি? কিন্তু এইটো কিন্তু মই এইটো maybe আমাৰ legislature বিলাকে কিছুমান নকৰে, এইটো কিছুমান ramification আছে, এইটো বস্তু এইটো গমেই পোৱা নাই। এইটোতো normally অকলে পঢ়ি এইটো লাগে যে review কৰিব। No, যদি দিব পাৰে, নাথাকিব পাৰে, ট্ৰাইব্যুনেল ৰিভিউ কৰা নাই, MSCত ক'ত ৰিভিউ কৰা।
ছেকেণ্ডটো কৈছে যে আপুনি এপ্লিকেশ্যন মেটাৰটো মেৰিটত ডিচাইড কৰিব লাগে।
আপোনাৰ
কৈছে যে আপুনি মেৰিটত কেছটো ডিচাইড কৰক, সেইকাৰণে সেইটো কৈছে। সেইটো একেটাই।
ৰিভিউ যে দিবই লাগিব।
লাষ্টৰ লাইনটো চাওকচোন।
Unless and until review is permitted by the statute, review to be inherent power নহয়। Appeal to inherent power নহয়। Appeal is a creature of statute, review is a creature of statute.
Powers to regulate its own procedure, কেতিয়াবা কিছুমান নিজে কৰিব পাৰে ট্ৰাইব্যুনেল, কিন্তু ৰিভিউটো নহব।
That's the powers of a civil court and the powers of a judicial.
এক্সপাৰ্টি নহয়, মেৰিটত আপুনি চাওক, এই প্ৰেয়াৰটো কৰিব
Regulate its own procedure for disposal of the case.
procedure. Procedure means quite an admission to the
It will be an interesting argument. Police.
for instrument has person expertly order for non-appearance proceeding submission code for hearing before the function.
মই deal কৰিছো। বোলে এইটো যদি সেই warrant দিব লাগে to only to file secure filing for review. That is not the objective. It was your required still that's not clear. It is already to মানে ensure presence, not to FTM, not to enable you to file a written statement. With the file code, warrant দিব লাগিছিল file নকৰাৰ কাৰণে। ইমান extend কৰি দিছিল ভালকে ডিল কৰিছে। We wanted to dispose of this matter. We had given more than an hour, but
Yes. Yes.
No, why not?
see, there is no dispute to the proposition of law that unless the statute in very clear terms vests a particular authority the powers of review cannot be done.
Yes.
Now here we find that some review powers have been given, but under what circumstance? Is it confined to an ex parte order or is it confined to any order? If it is confined to an ex parte order, then madam is out of that. But if it is not confined and open to other orders also, then she might have a case for a review.
Why not, as you know,
I got a
No, new discovery now.
No.
70 years.
আমি কৰিছো FT
No, Bangladesh why
review to decide নকৰিলে interesting.
লিখিব লাগিব ভাবা যে ফটোৰ পৰা আকৌ লৈ আহিব Pandora's books ভিডিঅ' কখনো পঠায় গ্ৰেট টু ইণ্ডিয়া নে কি বুলি কয় কাস্কেডিং ইফেক্ট
Cascading.
সেইটোৱে হ'ব
the parents section, no, the order 131. The right to file application within 30 days. Subsection 2 says has to be decided within 30 days by the tribunal. After filing. That is the matter. That's why there are two is inserted. The language, if your lordship reads once again, madam, whether foreigners tribunal has passed an ex parte order for non-appearance of the proceeding and or has sufficient cause for not appearing before the foreigners tribunal, it may on the application of the proceeding, if filed within 30 days, on the application of the proceeding filed, if filed within 30 days. That means application has to be filed within 30 days. the said order, set aside an ex parte order and decide on merit accordingly. Now, 2 says, my lord, the proceedee may file an application to the foreigners tribunal within 30 days to review the decision of the foreigners tribunal, claiming that he is not a foreigner, and foreigners tribunal may review its decision within 30 days of the receipt of the application and decide the case of merits. That's why the section says up to order 2 subset 3(2) is inserted. Otherwise, it would not have been necessary. That means application has to be filed within 30 days, and that has to be decided by the tribunal. That procedure has been given in para 2. That's why this para 2 has come. It's not independent.
No, it's not independent, but your approach may not be 100% correct. Though your end result is maybe the same, the 2 is only for orders in which the opinion has already been given.
Yes.
Because first is for those orders by which the tribunal makes a direction that we will proceed ex parte. Ex parte order is what? Proceed ex parte. We may not decide it today.
Yes.
Tomorrow you get notice of this, you get knowledge of this. This proceeding is proceeding ex parte against me. I file an application, please set it aside. And I contest. Now here, second is a situation where, see the language employed, claiming that he is not a foreigner and foreigners tribunal may review. That means he was declared a foreigner by an opinion which was ex parte. He files for a review within 30 days, and that review has to be decided within 30 days.
That review, no matter, Lordship may be correct, but the 3C, where the foreigners tribunal had passed an ex parte order. So there must be an ex parte order.
See, ex parte order may be two nature.
Yes, ma'am.
First, there may be an order, proceed ex parte,
Ex parte.
matter ends there,
Then
fixed
there-
on such and such a date.
Yes, then there may be opinion in ex parte.
And then in the same date,
Yes.
ex parte opinion.
Yes.
So if it's an ex parte opinion, 2 will come. If it is to proceed ex parte or alone, then he can file an application to get it satisfied.
Situation is that, my lord, when there will be.
Opinion is already there.
Yes. And in that case, my lord, if application is filed within 30 days, then another 30 days
For decision of the, yes, on review.
That is not there in the first paragraph. That is only in the second paragraph.
Yes.
It's in continuation of para 1. That's my limited understanding. Because the heading is, my lord, from very first day when I have read this provision, my lord, my understanding was that it is only against ex parte order. But as there are some different views, my lord, probably this has come up. But my limited understanding was it is only in case of ex parte.
Now, if you read again, see, the more you read, the clearer it becomes. First, has already this first section has already given the power to the learned tribunal to set aside the ex parte order and decide the case.
Yes,
There is no time limit fixed.
no time limit.
No time limit fixed, because if the tribunal gives an order, proceed ex parte, and the order is,
Recall.
not recall, order ends there, and
Yeah.
another date is fixed for opinion,
Yes.
then in the meantime, he can come.
Final.
This order, proceed ex parte is set aside, then we hear on merits.
Yes.
So that is the first.
Yes.
Second is, he has not come, we are proceeding ex parte, we already
Past an opinion.
passed an opinion, then he gets to know within 1 month he comes. If we mix out a case, it is recalled and we dispose of the case within another period of
30 days.
30 days. That appears to be one of the logical interpretation. Okay, we'll have some other day. When? We could not finish the matter. Meeting is again.
এটা কোর্টে কই except Monday.
Okay, my sister has a single bench also.
Yes, sir.
Okay, we'll have another date. When, madam?
Any date, Lordship, except Monday, Lordship.
Okay, we'll have some date. You also make some study. We will have in the first week of December.
Yes.
Okay?
Okay.
First week of December. Part No,
At 30.
no, not part. I'm not sure whether paucity of time did not permit the matter to be taken up. Full stop on request.
Judgment
List on
it will
first week
release.
December 2025.
Alright.